and 19. 2, 3, and 19, Your Lordship.
Yes.
Here, my lord, the engaged counsel DCK is out of station, Your Lordship. Finally, maybe matter may be taken up after 15, my lord.
Have you given?
Yes, I have taken consent from the other side, madam. As what, madam?
Item 2 and 3.
2, 3, and 19, Your Lordship.
2 and
Related to
3.
Nia case, Your Lordship.
You are applying for
Appearing for my lord, the petitioners.
appellant.
Appellant here.
Oh, SCKL.
No, my lord. On behalf of DCK, my lord.
Okay.
Advocate General.
On request made on behalf of Mr. SCKL. General Advocate General appearing on behalf of the appellant. When do you want?
My lord, on
Week, not this.
my lord, on the second week of June, my lord.
After 3 weeks.
After 15, my lord. After 15.
After 3 weeks.
My lord, my. Much obliged.
Same order, item number
19.
okay. Same order.
Much obliged.
May I please, your lordship? Lordship, I beg to mention item number 4, lordship. Item number 4, I appear on behalf of Mr. A.M. Bora, lordship. For the respondent number 1, I've taken the consent from the petitioner side, lordship. Finally, the matter may be taken up after 4 weeks, lordship.
On request made on behalf of M. Bora, let's. For responder
Respondent number 1,
number 1, just the matter for
after 4 weeks. Highly obliged.
May I please, your lordship? Lordship, I beg to mention item number 15, lordship. I have taken consent from the other side, lordship. This matter may take, lordship, after a week, lordship.
15 goes with 14,
15.
isn't it?
We have
14.
informed also, lordship, item 14 and 16, lordship.
14 to
Connected
16.
with 14 and 16.
Lordship.
Yes.
After a week, lordship, we
see.
have taken consent from the respondent, lordship.
Yeah,
Mr.
Mr.
Ayu Chaudhary, lordship.
On request made by Mr. Ayub Chaudhary, let me counsel for the appellant in criminal April 288 of 2019. Release the matter after 2 weeks.
After a week, lordship. Obliged, lordship.
May it please your lordship. Lordship, I'm praying for listing upon criminal appeal in the motion column. Lordship, next week on Monday, lordship.
Why?
Criminal appeal for motion, lordship.
When did you file it?
I filed it on 24th, lordship.
Then it will come in his usual course.
Lordship may kindly allow, if possible, next week on Monday, lordship.
Yeah, 7.
7th, lord. Obliged.
May it pleases your lordship. Lordship, I beg to mention item number 9 and 28 of the daily list, lordship. Lordship, my senior Mr. K. Goswami has been appointed as the amicus curiae in these two matters, lordship. There's some personal difficulty on his part today, lordship. It may come up any day next week.
On request made on behalf of K. Goswami, amicus curiae. Just the matter after 2 weeks. Same order in item number.
9 and 28.
Same order. Yes.
Obliged.
May I please your lordship?
Yes.
This is a mention memo for listing of a criminal appeal. Along with IA, kindly the matter be listed on 5th of June, 2022.
Why you want it to do? It is at what stage? Order stage, hearing stage, admission stage? What stage is it?
Orders.
Order. 9/25. 9th of June.
Highly obliged.
May I please, your lordship? Well, at the item 25, it is connected matter, my lord. It will start from item 20, my lord. Some personal difficulty, my lord, to maybe taken after vacation, my lord. Connecting matter.
You are appearing on behalf of?
Item 25, my lord. Anuddin, my lord.
Item 25.
Yes, my lord. Connecting matter from 20. It will start from 20. My
Yes,
friend
I'm
also here.
also there. I'm also there. No objection, man.
Okay, on request made by
After
NUD.
vacation, man, it will be better.
After vacation, my lord.
Learned counsel for the appellant in criminal April 62 of 2022. With this matter up to the summer vacation. 20.
No,
It
after
starts from 20, isn't it?
20, yes, my lord. From 20 to 25, the 26.
26.
Everything is gone. Yes.
Obliged, my lord. After vacation, my lord.
Item 1 for admission.
My lord, actually, in this case, the scan copy was called for, my lord. If it has come, my lord, I think it can go for a date of hearing, my lord, because it will be something to argue with, my lord.
LCS have come.
But I haven't checked it. I haven't.
Yes, my LCR one file has come.
HCL means a scan copy, no?
I don't know
Ah.
what this is.
It's written in the cause this problem, my lord.
We'll prepare the paper book then.
Let it be admitted and after vacation, a date may be fixed, my
It has
lord.
not been admitted yet.
No, my lord. Only notice of motion was given on 18/2, my lord, 21, my lord. Thereafter, because of some reason or the other, it was not taken up, my lord. 18 to 21, my lord.
This is an appeal against,
Not appeal, my lord. It's a criminal petition, my lord.
okay, it's a criminal petition.
Earlier, it was before the single bench, but because of the direction of the Supreme Court, my lord, it's coming up before the division bench.
Paper book will be required, not required.
May
It
not
will
be
be better, my lord,
Like it
or
was a-
better understanding of the matter, my lord. If the lordship feels, I've got nothing.
Criminal petition,
Not
I don't think the
Criminal
book is
petition not
required.
required. But Mr. Z. Kamal as a counsel for the senior counsel for the appellant. Admit. The LCS have been received.
I leave it to your lordship, whatever direction you.
This matter for hearing is zero.
My lord, there is an interim stay, my lord.
Okay, possible.
The interim. This is fine.
Lordship, I am not ever aware of the. Whatever order has passed.
Chair has been suspended.
18, so after vacation, it may be hard and disposed of.
That's in this usual
Yes,
course.
sure. ma'am. Much obliged.
Lordship interim, it's stay, as on day stay is there. Oh, name, there's no returnable date. Single bench is given, I leave it to you, discretion of the moment.
Victim of the past.
Item 5 to 8 for hearing.
But in this case, actually, I prepared the other cases today, my lord, but they have taken time. I could not prepare this one, my lord.
Yeah, in this matter.
Yes, my lord, because we have that appeal also, no, item 20, I prepared for that, my lord, but the other party took the time for petitioners, appellants, my lord. Mr. Nazimuddin also appears, he will probably do it. You want to do it?
Item number 5, 6,
Take as he'll do
6
it.
and 7, man.
You like to do it?
Some time may be necessary, man.
Okay, on request made on behalf of made by Mr. Z. Kamal and the council for the appellant. In criminal appeal 94, 2016 West.
But after vacation, my lord, it will be better. my lord. If it is not inconvenience, of course, my lord. Because he also appears in one item, he has some issues during vacation, my lord. Over Jabo Bilal. So, much.
माझा नाही ते.
Item 17.
10 to 13.
10 madam. Item 10 to 13.
13 is done.
Item 10 to 13. Lordship, 10 to 13 are connected repeal. Item number 10, amicus curiae is appearing. 11, senior advocate KK Mohanto. 12, I am appearing. And 13, it's out of the same judgment.
But all the councils are not present. Kiran.
Now to only 2 councils. I am, item 12, I am present. Item
Where's
10,
DK Manda?
no idea.
This is here.
SSDR was here. The check.
It's also there. What? This is.
KK Mohanto is coming, that's what. I just called up his son. He said he is coming.
Oh.
KK Mohanto, senior advocate. And here.
May it please, your lordship. Lordship, may kindly pass over the matter for some time. My senior is at Lex at Kotumo 14, lordship.
After some time.
Yes, lordship.
We have no problem.
Where about Zia?
Yeah, item 13 is here. And I guess he is also here, it's just he probably is trying to cover. So after some time we can.
Much obliged.
Item 17.
May I please your
Lordship, Miss Jahan dealt with the matter. She's having some personal difficulty today, your lordship. She has not arrived court as of now. She might arrive, but she might be late, my lord. Can it be taken up some other day, tomorrow, day after? I don't have that copy of the paper book, your lordship. If your lordship permits, I can read from the. Lordship.
Slowly.
Please, something to nice, something nice.
Item 18.
Oh. I have single bench. We have single bench.
18 is appeal against acquittal, your lordship. Monthly accused of an. Purva?
I am appearing on behalf of P. Kotopi. Kindly adjourn the matter for today. He late another court.
P Kataki.
P. Kotopi.
List of the things.
Of license.
May it please your lordship. Well, before I start, it's a matrimonial appeal, my lord, in which on the last occasion, the Honorable Division Bench was pleased to direct that both the parties be present. Accordingly, the secretary was asked to, regional secretary, to inform the wife. And so far as my client is concerned, he's there. But this being a matrimonial appeal, and in version of, and in terms of the section 22 of the Hindu Marriage Act, perhaps I leave it to your lordship. It might be in camera proceedings.
Why?
Section 22 of the Hindu Marriage Act. Of course, your lordship may take it. Of the Hindu Marriage Act.
All the parties are here.
The husband is here. The wife never appeared before the family court, never appeared before the High Court, even after service of notice. So as a last resort, in the last occasion, the Honorable Division Bench expressed that the order is there, 20th of April. The only case is that, gentlemen,
Yes.
but so far as the situation now, since he is there, in his presence of bigger submission, the marriage is broken down irritably. There's nothing left.
No, just a minute.
Whether in camera, some questions may be put, therefore I'm.
What I'm thinking is let the wife come on.
She would not, that is what I'm submission is, before the family court, even after service of notice, did not turn up. Here in the High Court also, after service of notice, did not turn up. Gentleman is here crying that I want to pay money to my daughter. I want to pay money to my wife. I want to take the responsibility for life after divorce. Whatever, even now, if I'm not correct, her wife, his wife is being funded by the in-laws. She is not even accepting her money. No communication, nothing. Even if the court notice would go, she would not turn up. So therefore, let it come to an end. The marriage is gone. Nothing is left. It's one of a case where the husband is saying that I need to pay to my wife, I need to pay to my daughter. There are some responsibilities with me. Whatever I earn proportionately, I'll pay that. Kindly end the marriage because there is no physical relationship. There is no even communication left. Even court notices are being ignored, deliberate.
Manik, what we are proposing is,
Lordship.
we want to give one more chance as a final option. This being the High Court. We would like to give her one final opportunity.
One final chance.
Yes, if she does not appear, then we'll finish up.
My lord, since he is presently posted in Bangalore, so may I pray a date conveniently be,
Convenient to him.
when can you come down again? July, after vacation. July after vacations, my lord. That will give some reflection time as well.
But there's Bunny going to come to put an appeal. None appeals to the respondent. Correct. By order dated 24/2023. The respondent. Is there any note from the, with regard? Selected by order dated 24/2023. The secretary DLSA, Kamrup, within bracket, Metro, was directed to intimate the respondent to remain present in court on the next date of hearing, I 35/22, to explore the possibility of an amicable settlement. However, the respondent is not present, nor is there any report from the secretary DLSA, Kamrup Metro, whether the respondent has been notified about the same. Accordingly, new para. The secretary DLSA Kamrup Metro is directed to intimate the respondent once again to remain present in court on the next date of hearing to explore the possibility of an amicable settlement. The secretary DLSA Kamrup Metro shall also file a report as to whether, with regard to file a report to indicate that the respondent has been intimated to be present in court on the next date of hearing. When do you want?
July after vacations.
List the matter again on
18, Lordship, it may be or June last, my lord, if possible. The week commencing from 26th,
27 June.
27 June, and if I'm permitted, my lord, Lordship may also indicate that the registry to send this to the jurisdictional secretary.
27 June
27 June.
or 27 June. Registry is directed to furnish a copy of this order to the secretary, DLSA, Kamrup Metro.
My lord, may also record that the husband is present in terms of the order, in compliance of the order,
The applicant.
in person.
Heard Mr. Is Bunny going to come for that applicant? So applicant is also present in court. In person.
Objection, my lord. Obliged.
Item 10 to 13.
My lord, I think, Learned Senior Counsel is in court number 14. Matter is going on. Matter is going on. I am for item 10. My lord, we can start if required.
Yeah, we can start, there's no issue on that. But the thing is, we don't want to keep it part-heard because this bench is not sitting
My lord, I understand.
after this. That is the problem with this.
My lord, that is understood. So, my lord,
The only issue is, can we complete it today?
my lord, that will be a difficult matter because I will be taking some time to go through this in respect to I will take a couple of hours and senior counsel will also take a couple of hours. It will perhaps not be possible to finish today. Ma'am. That is an issue.
Can we finish it this week?
My lord, we can finish it this week. My lord, not today. I mean, I said perhaps possibly not today, but this week we can finish it. Yes. On a day-to-day basis, if we conduct that. Tomorrow also, if it is carried over, it can be finished.
All parties are present except Mahanda.
Yes. This is here. Code number 14 is.
Mahanda he's coming.
He's coming.
You are the amicus curiae.
And the amicus curiae.
And item 12,
I am for item 12.
item 12. How about item 13?
Item 13, council was here only.
Mr. Zia, we can call him. In the meantime, we can. Anuddin also.
Enuddin.
He was here only.
Mr. So, my lord, in order to understand the brief facts of the
This
case,
is with the understanding that it will be completed this week.
we'll complete it madam, this week.
Yeah.
I don't know
Tomorrow-
how long they'll take, Tomorrow, one more part-heard matter is fixed, Manu. Mr. BN Gogos
We won't
will
take
raise
long. I'll just go through this.
That
but
is your thing. but
And
others
my friends also, I believe he's not in the FIR. He's a different
My
case.
case, if only my case is taken, it will take only 15 minutes because my
Yes.
name comes in the FIR and it comes in the judgment. In between, there is no reference of my name. Item number 12. That may be noted while reading the judgment. My client's name is Mia Hussain. It comes in the FIR and it comes in the judgment. Okay.
Yes.
Item 12. Nowhere else is my name, nothing, no. There is a extrajudicial confession, his part is extrajudicial confession. The other two, in the case where Learned Senior is appearing, there also, his name does not come. So that is the whole crux of the matter. The case is based only on extrajudicial confession and chain of events.
Anyway, all of you were convicted.
Yes, all of us are convicted and I was convicted because my name was in the FIR. There was no circumstances, nothing to say against me.
But they were a member of unlawful assembly. Unlawful assembly.
Listen. My lord, may I start begin, my lord? My lord, may turn to
Your
page.
item 9.
I am item 10. The convict's name is Habibur Rahman. In this case, my lord, may turn to page 78, where the entire brief.
One minute. Yeah.
My lord, may kindly turn to page 78. For the brief facts of the case. May I read?
Yes.
I'm reading my notes. In the morning of 14 April 2008, page 78 of the paper. In the morning of 14 April 2008, PW2, which is the informant, the wife of the deceased, informed the co-villagers, the VDP and the village headman, Nurul Islam PW1, and went to the police station at around 7:30 a.m. My lord may note these timings as well. These are also important. 7:30 a.m. PW1, PW3, 4, 5, 6, and 7
the other witnesses examined, also told that they informed about the matter by PW2. Now, my lord may note this. All these witnesses were informed about this matter by PW2, who becomes the prime witness in this case. They all heard it from PW2, the wife of the deceased. Now, as per PW1, while he was going to the house of the PW2 at the market, he saw some villagers caught hold and cordoned accused Hobi and Ajijul. My lord may note these names also. These will also have relevance. Accused Hobi and Ajijul, the villagers caught hold of them, and he informed Dhing police station over telephone. Police came there and took over the accused persons. On interrogation by police, the accused had admitted that they had killed deceased Ajibur Rahman and concealed the dead body on the ground in a neighboring shore, which is situated at a distance of 1.5 kilometers away from the house of the complainant Rumena Khatun. This is PW2. Then the villagers along with the police went to the site led by accused Habi and Ajijul, where the dead body was buried. Now, my lord may also note this. The villagers went along with the police to the site led by accused Habi and Ajijul, where the dead body was buried. This has been discarded later on, my lord. I'll just take it to lordships. Where the dead body was buried, and after arrival of the magistrate, the place was dug out and the dead body was recovered. Now, as per PW3, after detection of comforter, which is the muffler, a pair of slippers and a bicycle on the river bank, accused Ajijul and Habibur were brought to the market by the public, and there the accused persons confessed before them that they, along with Fakhruddin and Sahed Ali, the other convicts, killed the deceased and buried the dead body in the char. As per PW4, he saw Ajijul and Habibur Rahman confined by the people at Matkula Bazaar in front of the pharmacy of so-and-so, and on asking accused, Ajijul and Habibur Rahman told to them that they, along with so-and-so, and few others have murdered Ajibur. PW4 also stated that at the time of confession by both the accused persons, Zahid Ali, Javed Ali, Haspat Ali, these are people who were there at the scene. And many other people were present there at the time of the extrajudicial confession. The defense in his cross-examination has not brought any material to show that there were forceful circumstances to the accused persons for their confession before the public. PW5 also stated that on the relevant day, accused Ajijul and Habibur were brought to the market in his pharmacy, and both the accused persons confessed that besides them, accused Sahed Ali and Fakhruddin committed the murder of Ajibur. Now, as per Dhing PSGD entry so-and-so dated 14/4/2008 at 7:55 a.m., police got information from the VDP secretary of number 2 Kandli Mari that a person has been murdered and buried thereafter, and 2 persons have been intercepted. It can be seen that the dead body was recovered by the police, not in consequence of information given by the accused. Rather, the police already got the information regarding murder of a person and his burial. Thus, there is no discovery of information purportedly given by the accused, and as such, Section 27 of the Evidence Act is not applicable in this case, my lord. So, there is a finding that there was no discovery leading to the discovery of the body, dead body as such. Rather, the people told the police that there was a burial and the player's dead body was buried at some place in the chart. So this finding has been categorically given by the learned court below. From the evidence on record, it is established that before arrival of the police, accused Habibur and Ajijul were caught by the villagers and they confessed about the murder of Ajibur. Dead body of Ajibur was recovered by the police in presence of magistrate and villagers. All PWs have substantiated this fact. Now the place from where the dead body was recovered is an open field where jute seeds were sown. The dead body was buried and it was recovered after digging the earth as shown by accused Habibur and Ajijul. So my lord, there is a contradiction here. On one hand, it is said that there is no discovery. And on the other hand, it is said that as shown by the accused Habibur and Ajijul. So my lord, those two facts do not go together. Findings do not go together, my lord. My humble submission in this regard. And this fact clearly indicates that a dead body was hidden and it was within the knowledge of accused Habibur and Ajijul and none else. From the evidence, the following facts has been established. Now, my lord, as per PW2, wife of the deceased, accused persons on 14/4/2018 at about 6 o'clock in the afternoon took away her husband from their house, telling that they had some discussion regarding earth cutting, but he did not return home. Number 2, in the morning, PW2 informed the villagers about missing of her husband, and thereafter villagers caught Habibur and Ajijul and they confessed before villagers about the murder and burial of Habibur and Ajibur, and PW 1, 3, 4, 5, 6, and 7 have substantiated this fact. 3 in the morning, dead body was recovered by the police in the presence of magistrate and villagers as shown by accused Habibur and Ajijul. It can thus be seen that the chain of circumstances is complete. Now in the FIR, it is stated that quarrel and dispute existed between the accused persons and the complainant side. In a cross-examination, PW2 has stated in a cross-examination that accused persons have some dispute with her husband, which indicates the motive of the accused persons. So, my lord, from the evidence, it is thus established that it is none other than the accused persons who killed Ajibur, and in order to cause disappearance of evidence, the accused persons buried the dead body of the deceased. There is some discrepancy in the testimony of PWs, but these are bound to occur as each PW will narrate the incident in their own language, and these discrepancies do not affect the root of the prosecution case on material point. Post-mortem and evidence of PW8 substantiate the fact that death of Ajibur was caused due to injuries sustained by him. So, my lord, this brief circumstances are that there is a quarrel which is shown, quarrel and a dispute between the convicts and the person who was deceased, as per the testimony of the wife of the deceased. Second point is a chain of events is shown that on the date those convicts came, 2 of those people came with other people to take away the husband of the deceased from his house at 6 p.m. in the evening. Thereafter, he was missing. In the morning, she raised an alarm. The villagers came. And at this point, things become hazy as to who discovered the body. Because, my lord, the trial court has stated categorically that there is no discovery. The police may have been led, police had got the information regarding murder of a person and his burial at a time of them being phoned by the VDP and the VDP secretary. So they got the information over the phone that there has been a murder, there has been a burial. It was not the accused persons who led the police to the place where the body was buried. That information was prior to that. So even after that, the learned court has held that the chain of circumstances is complete on the basis of the fact, the theory of last seen together and the motive. So, my lord, this is the brief facts. My lord, I will take my lords to the depositions of the prosecution witnesses. One by one, let us see, my lords, whether these depositions.
Who lost the FIR?
PW2, that is the wife of the victim, lodged the written ejaha at Dean Police Station on 14/4/2008. 14/4/2008. And now, my lord, may come to the PW. My lord, I come to page the written ejaha. The ejaha is at page 4. My lord, may come to that complaint. Page 4. The informant, Mr. Rumena Khatun, that is later she is the deposes as the PW2, and the accused, Mohammad Fakhruddin, Mohammad Abdul Hakim, Mohammad Abdul Karim, Mohammad Abdul Rahim, Mohammad Habib. Now, my lord, there is again the issue here that Habib has been, I will take my lords to the place where Habib has been referred to as Habibur Rahman, Hobi. Different names have been used. The problem arises from here, which I will take my lord to in the depositions as well. Number 6 is Azizul Haq, 7 is Mia Hussain, which is item 12, and then Sahed Ali. Now, of this, my lord, I believe one has been declared as an absconder and convicted in absentia. This is Mohammad Fakhruddin, and one has expired. So, all in all, 6 persons were convicted. Right now, my lord, I'm only concerned with accused number 5, Mohammad Habib. If I may read the ejaha, page 5. Sir, I have the honor to state that we have been in bad terms with the above named accused persons with regard to certain issues for some time. Since after the dispute arose, the above named accused persons are in search of the opportunity to cause harm to us. At about 7 p.m. on 13/4/2008, it's the above named accused persons, I believe this is 13/4/2008. I do not have the original, whether it's 13/4 or 14/4. 13/4/2008, yesterday, I will believe the date on before the date on which the ejaha was lodged. So she says 7 p.m. on 13/4/2008. The above named accused persons came to my residence in a group and called my husband Mohammad Azibur Rahman on the pretext of discussing certain important matters. Then when my husband pulled out the bicycle from our residence, I held the lamp to show him the road to outside, and I saw the accused persons in the gleam of the lamp. But my husband didn't return home within the night. I informed the matter to the people in the morning, and when people caught and questioned accused numbers 5 and 6, they confessed that they had killed my husband and kept his body buried. Later on, people handed accused numbers 5 and 6, who are Mohammad Habi and Azizul Haq, to the police. I pray to your good self to investigate the matter and necessary steps in this regard and oblige. My lord, 2 facts come out clearly from this FIR. There is no specific allegation as to what enmity is there. There is some enmity, some dispute, and they're looking for us. Number 2, it's about 7 p.m., which is dark, because the lamp was used to identify who are the persons who were taking the husband along. So it is dark time. And there is no test identification parade conducted on any of the accused. My lord. Earlier, this problem would not have assumed much significance if the time of occurrence of taking the husband had been 6 p.m., because at that time it would have been light. It would have been sufficiently light to identify the accused by their faces. If they are familiar with, if the wife of the victim is familiar with those accused persons, she could identify easily in the dim twilight as well. But this is dark time. She has lit the lamp and she's taken the lamp outside, and therefore, first point here which I'm raising is that there needed to be an identification parade. This point assumes significance later on when we come to another witness's testimony, the main testimony of the PW2. So, my lord, now, my lord, before going on forward, I would like to bring to your lordship's notice the fact that since the time of his arrest in 2016, my client was in custody since 2016, all throughout. Rest have been on bail, but he has been in custody since 2016. And that fact again assumes significance once we read the deposition of the witnesses. So, my lord, I'll take a note to page 8. PW1. PW1 is Nurul Islam, who is the headman, I believe. Headman. Headman. PW1. Can I read, my lord? I know all the accused persons by name. They are my co-villagers. I know complainant Rumena Khatun. Rumena Khatun lodged an FIR on the 1st of January. I believe this date is wrong. I could typo. It cannot be the 1st of January 2008 at Ding police station for the death of her husband. On 1st of January, again, the date is wrong. In the early morning at 6 a.m., informant Rumena went to my house and informed me that the accused person seen in the dock took her husband to Romari village for some earth digging discussion. She reported to me that her husband was called out by the accused and did not return till morning. She informed me that she had reported the matter to the other villagers and she requested me to go to her house. Accordingly, I went there. Before I reached the house of the informant, while I reached the market, I saw that some villagers had caught hold and cordon accused Hobi and Ajibul. Hobi is not within the dock. He was declared absconder. Now, my lord, this is the problem that arises. I was in custody since 2016. I was never an absconder. I had to be within the dock. There is no, from this, it is not clear who this PW1 has identified as Hobi. There is only one absconder, and that is Mohammad Fakiruddin. And he is saying that accused Hobi is not within the dock. He's an absconder. This is a material contradiction here. I was within the dock. I was in custody. And therefore, when I saw this, I immediately informed Ding police station over telephone. Then the OC of Ding police station came over there and took over the 2 persons. When police interrogated them before the public, they had admitted that they had killed the deceased Ajibur Rahman. My lord may also note this. This is a different version. The above named accused persons made a statement before the IO that they had concealed the dead body on the ground in a neighboring shore, which is situated at a distance of 1.5 kilometers away on the northern side of the house of complainant Rumena Khatun. After hearing this statement of the accused, we, the villagers, along with the police and the above named 2 accused persons, went to the site where the dead body was buried. And on being shown by the accused, which is being shown, the exact spot, we, the villagers, cordoned the area along with the accused. So the villagers said that they were shown the dead body by the accused and they cordoned the area. The police officers told us that he would inform the magistrate. They are saying right now they went along with the police. My lord, the statement is that the villagers went along with the police. Then where was the need to cordon off the area? The police officer told us that he would inform the magistrate and await the arrival of the magistrate. After a while, the magistrate arrived. The place was dug out with the help of accused Obian Ajijol. Then the dead body was dug out under the ground. Exhibit 1 is the seizure list. Exhibit 1 is my signature. Therefore, after the police and magistrate took away the dead body as well as the accused. Now, my lord, the cross-examination. When I put my signature on Exhibit 1 in the seizure list, I could not say what were the contents of it. I have been shown muffler and sandal, the comforter and the sandal, before taking the signature on it. He has not been shown the bicycle. The seizure list was prepared at the place of occurrence by the OC and he took my signature. I have made the statement in the court on the basis of the information received from Rumena Khatun. This is important, my lord. My house is situated at a distance of 1 kilometer from the house of the complainant. There is a public road passing just by the side of the house of Rumena Khatun, and the villagers used to go through the road. The name of the market where the 2 accused were detained is number 2 Kandulimari Matfula Bazaar. When I reached the said market, the villagers detained 2 persons there. So, my lord, there were around 500 villagers present in the market. So, my lord, this is important point. The question was before the trial court that whether this was a forcefully extracted extrajudicial confession. 500 villagers gherawing 2 accused. My lord, I submit before lordship, there was a mortal fear of harm. Such judicial confession extracted in presence of 500. Later on, it says there are 1,000 villagers. Then later on, another witness says that no, 1,000 villagers were outside the shop. They were later taken on inside the shop, and there they confessed before, say, another 20, 30 villagers. The version keeps changing, but my lord, my submission is that there is a sufficient evidence to show that there was substantial population heroing these 2 accused, and this could not be treated as a voluntary confession. The police came and took the custody of the 2 boys. The police officer recorded the statements of the accused persons. I have not seen where from those 2 boys were brought to the marketplace by the villagers. The shore is situated at a distance of 1.5 kilometers from river embankment. It is an open place. The shore is normally filled by river water during the rainy season. At the relevant time, Jahed Khan, Master, Qasim Doctor, and many people were present. The VDP Secretary, Qasim Ali, and VDP President, Qasim Faraji, were also present. It is not a fact that the 2 accused persons detained there made any statement confessing their guilt. Now, this is a vital statement. He has denied the suggestion. It is not a fact that the 2 accused persons there made any statement confessing their guilt. He has denied that they have confessed their guilt anywhere. So, in that incident, the 2 boys were detained in the market. There was a tussle and fight with the police officials and the public of the shore area. There was a fight between the police and the public as well. I, along with some village elders, tried to intervene in the tussle, as a result of which the police officer lodged a case against us, in which a case was instituted, and I was acquitted in that offense. A very, very vital point. This is an witness against whom there were police proceedings going on at that point in time, and he could not be called as an impartial witness. He was possibly under some form of influence, because there was a fracas. Case was registered in him in respect of that same incident at the fracas. And again, during that time, he says, I was acquitted in that offense. A trial had gone on. While there was preparation of inquest report at the time of digging out the dead body, I was present, but my name was not taken as witness on the inquest report. The informant reported about the incident to the OC of the Ding police station. And subsequent to that, I informed the OC while I saw the detention of the 2 boys over phone. I informed the OC while I saw the detention of the 2 boys over phone. My lord, again, this statement, the informant reported about the incident to the OC. And subsequent to that, I informed the OC while I saw the detention of the 2 boys over the phone. This is in contradiction to the FI itself, where it says the secretary phoned the police and informed them. So at this point in time, my lord, the waters have been further clouded as to who informed the police and at what time. whether the police were informed by the time the accused were caught by the villagers, whether they came at the time the accused had already been heard and confessed before the villagers, and the merely handing over to the police became an empty formality. Well, that is an issue here now. The police, after their arrival, examined some of the witnesses at the place of occurrence, including me. I was reported by the informant about the incident on 1/1/2008 at 6 a.m. This date is wrong, perhaps, I believe. It is not a fact that no incident took place on 1/1/2008. Again, my lord, he is denying that some incident, he's actually stating that some incident took place on 1st of January 2008. Because it may be a typographical error, my lord, the date, original meaning. PW1.
তুমি কোথায় আছো? I'm for two appellants. In the first appeal, I'm sorry I was struck up. Lordship is hearing the other side. No, other appeals. Here, Lord, I am appearing. Criminal appeal to Kiman. 414, my lord. Item 11, we are appearing there. And I am appearing on behalf of the appellants. They are here number appellant. Lordship will find my two appellants, Abdul Hakim and Abdul Rahim. They are the two persons who are appellant before your lordship. They were the accused in this Abdul Hakim.
Mr. Manda,
My lord.
arguing the matter now?
I
Arguing now?
propose to argue if your lordship hearing the other side,
I was hearing.
then let that be completed.
Yes,
Then I will come back to my case.
Okay.
Because they are jail appeals, I suppose.
yes.
They are jail appeals. Lordship is hearing the jail appeals. After completing their hearing, I will come back because I am on bail. Now we are not in jail. So then lordship can hear me because I can only support my case.
Yes.
I will not go through the other part. Therefore, lordship may hear them. Finish it. I'm sorry that lordship, I interrupted your lordship. Lordship may complete that part. I'll come back. Oblige.
We will require your help.
My lord.
Just show her this one. Maybe this. Maybe it will be done.
Now, my lord, this matter normally I would not stress so much for other than for two aspects. He is on 3 or 4 occasions, he has been particularly vehement that something happened on 1 January 2008, and he has said that he's not lying about it. But it is an admitted fact that the incident took place on 13/4/2008. My only purpose here is that to cast doubt on the credibility of the particular witness, which the prosecution has tried to show as saying, showing unimpeachable evidence that so and so has confessed. So, my lord, that is my only aim in this regard. This particular contradiction may not but impinge on whether who is guilty or what event took place on 13/4. But the witness itself does not appear credible in the principle.
Lordship, this part at page 10, my lord.
That is a photocopy. It's a photocopy
Uh,
of the original.
Yes, it's in English only, my lord.
Yeah, but on the other side,
Yes,
on the other side,
on the other side, it's in vernacular.
what is it? What is that?
The paragraphs of Habibur Rahman.
Part of Quran.
Yes,
That is
it's in Assamese, but it's translated here.
This is the part of this.
Lordship, page 11. Lordship, I'll try to translate it, my lord. এইটো সত্য নহয় যে আসামীগণে আমাৰ আগত আৰু পুলিচৰ আগত আজি জোৰক হত্যা কৰি পুতি থোৱা বুলি স্বীকাৰোক্তি দিয়া কথা সত্য নহয়।
That is prior to that.
No, prior to that, it's in English. Lordship, page 10, it's in English. And here it's also in English, my lord.
11 is the translated one.
Yes, no, not the translated one. It's all the same. May I read, my lord, that portion? I was reported by the informant about the incident on 1/1/18 at 6 AM. It is not a fact that no incident took place on 1/1/8. It is not a fact that I have stated about the date out of my own imagination. It is not a fact that informant Rumena had not reported anything to me as stated. It is not a fact that the accused persons are innocent. This is the portion. It's in English, my lord, which is extracted here in page 10.
Yeah, that part.
Photocopy.
That
Yes.
part, yes.
Then thereafter, it's in vernacular, your lordship. Its translated portion is here at page 11.
So, my lord, this is one point is the page 10 is his reiteration of 1/1/2008. Next line, he says, it is not a fact that informant Rumena had not reported anything to me as stated. Now, if my lord turns back to page 9, at around the second paragraph, 4th line of his cross-examination initial, he states that I have made the statement in the court on the basis of the information received from Rumena Khatun. So, my lord, this he has clear admission of the fact that entire evidence is hearsay. He has heard everything from the PW2 and he has basically parroted the version of PW2. Whatever he has said in court, this is an omnibus statement, and that he has been on a suggestion being put to it, he has affirmed that it is not a fact that informant Rumena had not reported anything to me as stated. So, my lord, these are the two facts which I am pointing out, my lord, regarding the credibility of this witness in question. Now, my lord, may come to the next page, the further cross. I will read in English. Page 11. It is not a fact that it is not true that accused persons confessed before us and the police that they killed Azibur and kept his body buried. So, there is a suggestion has been denied. Rumena did not inform me that night that the accused persons had called her husband away at night. She informed me in the morning. It is not a fact that I have deposed falsely. The dead body was recovered as shown by the accused. Having learned that the police had come to Matikula Bazaar, I went there. Rumena had gone there before me. I met Rumena there. I came to know most of the things from Rumena in front of police. Again, one of the material contradiction. In this examination, chief, he says that Rumena had told him in the morning, early morning, that please come to my house. There's something important. basically told him the facts of the case. Thereafter, he went to her house. On the way, he went to the market. Now he's saying that he went to the market, Matikula Bazaar, and she had gone there before him and he met her there. I came to know most of the things from Romena in front of the police. I don't know the name of the magistrate who went there at the time, which is not a fact that I have adduced false evidence against the accused persons. So, my lord, further contradictions in PW1. But my lord, from as I had earlier stated before your lordships, all the witnesses have stated they have heard from PW2. So basically, it all devolves down into what PW2 has said in her testimony. So my lord may come to page 12, which is the deposition of the PW2. That I will read. Now, I know all the accused persons, they are from my village. The occurrence took place on 14/4/2008. Lord, again, this is a problem because I do not know whether they're on 13/4, 6 p.m. they take the husband away, and morning she simply reports that her husband is missing to the villagers. So occurrence, whether it took place on 14/4 or 13/4, that only perhaps the post-mortem report will come to know, my lord. On the day of occurrence at around 6 o'clock, again, this is around 14/4. On the day of occurrence, she's referring to 14/4. In the afternoon at around 6 o'clock. In the afternoon, my husband Ajibur was taken away from our house by the accused persons with the information to me that they had a discussion regarding earth cutting towards Romari. Accordingly, my husband went with the accused persons. I was waiting in my house, but my husband did not return till morning. During night hours, my lord, another additional statement here. During night hours, some co-villagers came to my house and I informed them that my husband had not returned. I informed about the fact to Asghar Ali, one of my uncles who has already expired. In the morning, I informed the co-villagers, the VDP and the village headman, Nurul Islam PW1. Then I went to the police station at around 7:30 a.m. So she says she has gone to the police station at around 7:30 a.m. The police came. Consequent to her going around the police station, the police came and the dead body was recovered. Police detected the bicycle, sandals, and muffler of my husband at the place of occurrence. I was also present there at that time. The police were waiting, and when the magistrate appeared there, the dead body was dug out from the spot. The dead body was my husband's dead body. The dead body was taken by the police for post-mortem examination. Later, the dead body was handed over to us, and we cremated the dead body as per our rights. The place of digging the dead body was spotted by accused Hobi and Ajijun. Exhibit 2 is the FIR, and Exhibit 2 is my signature. Cross-examination. My lord, then I'll go on to the cross-examination. I lodged the FIR on the following date of the occurrence before recovery of the dead body. My lord, so when has the FIR been launched before the recovery of the dead body? Subsequently, again, this is thrown into doubt. Before filing written FIR, I also informed the police orally about the incident. So again, the police has been informed orally about the incident by this time by the PW2 and also by the VDP secretary. So again, it is not known as to when exactly the police came to know about the incident. The police immediately went to the place of occurrence. The bicycle, sandal, and muffler of my husband were lying on the river embankment. From that point of the embankment at a distance of 1 kilometer inside the shore, the dead body was recovered. When the dead body was dug out, I was also present there. The FIR was written by the police officer. So, my lord, again, the FIR was written by the police officer and she appended her signature to it. So again, she says that she has lodged the FIR before the recovery of the dead body. Then the FIR is written by the police officer. Then when is the police informed? Early morning, late in the morning. These time of events are not clear, my lord. In front of our house, a road is passing through the courtyard and it is a common village road. On that road, villagers used to pass. I could identify the accused when they came to our house with the help of a lamp, Saki. So, my lord, at 6 o'clock in April, it is not dark. There is no requirement of a Saki. It is twilight. My submission is that it is more probable that as she has stated in the FIR, it is 7 o'clock in the afternoon. Here she states it is 6 o'clock and in the afternoon in her in her deposition she states it's 6 o'clock. My submission is that if that were the case, the lamp would not have been required. The lamp Saki was not seized by the police. The accused persons are my close neighbors adjacent to our house. They are cousins of my husband. We had a dispute between the accused and my husband. Before this incident, I lodged a complaint against one of the accused, namely Fakaruddin, who is the absconder, while he attempted to outrage my modesty. It is not a fact that for reason of having strained relationship with the accused, I lodged a FIR against all of them. Today, accused hubby is not seen in the court. Again, my lord, I am in custody. I am not seen in the court. Ajijul is present. All throughout, my lord, my client has never been identified. And that too by the prime witness, who is on whose witness everybody else is basing their testimony around. There is no mention of any other place where I was identified specifically as this is the person, Hobby, who took my husband away on the evening of the occurrence or prior thereto. There is no clear identification of the appellant herein in this manner and my submission. My name is also been taken wrongly. In one place, I've been named as an absconder, whereas I'm not in absconder, I'm in custody all throughout. And again, is not seen in the court. If I'm in custody, why? There is no reason for me not to be in the court. I cannot take a leave of absence from attending the court. I must be produced in the court. It is not a fact that no incident took place on 13/4/2008 as alleged. When my husband went out from the house, he was going comfortably with the accused. So my lord, you're saying he was going comfortably with the accused in this case. Now further, my lord, page 14 is the further cross-examination where more contradictions come out in the testimony of the PW2. Page 14 on oath. After lodging of the FIR of the Ejahar, police did not come to the place of occurrence with me. They came later on. Police went to Matikula Bazaar for investigation. Then I went there and met the police. I so-and-so torn in original after police had exhumed the dead body. So now my next paragraph, we had no quarrel with the accused persons prior to the incident. So therefore, my lord, that motive has been blown away, my lord, by the prime witness as such. We had no quarrel with the accused persons prior to the incident. It has not been mentioned in the Ejahar that there was quarrel. And she disowns the Ejahar. The Ejahar was written by someone at Dhing Bazaar. So Ejahar was written by the police. Now the Ejahar appears to have been written by someone in Dhing Bazaar. And a third contradiction. I don't know who wrote it. So now she disowns the earlier statement that first she says, I lodged the Ejahar. Then she says the police wrote the Ejahar. Now she says, I don't know who wrote the Ejahar. Somebody at Dhing Bazaar wrote it. The contents of the Ejahar were read over to me. Having learnt about the arrival of police at Matikula Bazaar, village headman Nurul Islam and witness Zahid Ali also went there with me. The village headman was informed before the arrival of the police. So that part ties in with the statement of the PW1 that he was informed by PW2 prior. That is why he went to her house, perhaps, and there went to the market. It is not a fact that it is false on the previous day of the occurrence. The accused persons called my husband away and that I recognized them. It is not a fact that I lodged case bringing false allegation against the accused persons out of grudge. So, my lord, PW2 has, in my humble submission, dismantled the motive aspect as well as lent credence to the testimony of PW1, whereby there has been a misidentification of my client that he's not there in the dock, whereas all throughout I was in the dock. So somebody else, they were possibly thinking of somebody else, calling that person Hobby, and my name being Habibur has been shortened to Hobby by the police. And I've been made to stand trial for that reason. That is my submission regarding that particular aspects of PW2. So far as they relate to accused number 5, my client. Now, my lord, PW3, these are, I'll be narrating these in brief. I'll not go in detail. The PW3, he stated that the brief thing is that articles such as muffler, comforter, slippers, and bicycle were discovered lying on the river bank which PW2 also states. So I'm just giving a brief account of this. These articles were recovered by the villagers prior to the arrival at the Matikula Bazaar. Now, my lord, I know the accused person seen in the dock. Occurrence took place some 3-4 years ago on the day of first Bohag. After the morning prayer at Masjid, I was sitting at the tea stall at that time. Some villagers along with the VDP and the Gaubura came there and informed me that one Ajibur deceased was called on by the accused last night, and since then he is missing. They also told me that some articles like a comforter, pair of slippers and a bicycle was lying on the riverbank. Now, my lord, the articles of the dead body deceased, the villagers knew they were lying there. Everybody seems to have known that some articles of the deceased person are lying on the riverbank. It is not a case that only the accused knew that those articles were lying there. And I, along with the others, went there and found the same. So the villagers discovered the articles of the deceased. There I saw that the accused Ajijul and another Habibur were altercating with villagers when they were asked by the villagers to find out the deceased. So this is another version, my lord. There the two accused were asked by the villagers to find out the deceased after the articles had already been recovered by them. Thereafter, both of them were taken to the market. And after little interrogation, this is where, my lord, the coercion aspect comes in. After a little bit of interrogation by the villagers and the VDP. So the villagers interrogated the accused. They confessed before us that they, Ajijul, Habibur, Fakhruddin and Sahed Ali, killed the deceased and buried the dead body in the char. So there is an extrajudicial interrogation as well, leading to an extrajudicial confession. After some time, the OC of Dingpli, PS Sushil Datta arrived there, and along with him, we proceeded to the place where the dead body was buried as needed by the accused. There was no need for the accused to lead them. Everybody knew where the articles were there. They had already interrogated and they had already taken the accused from that spot itself, brought them back to the market for interrogation. So there's no question of leading at all. Most probably half the village knew that those articles were lying on the riverbank. Both the accused Ajizul and Habibur dug out the dead body in front of the villagers and took back the dead body. Police made a seizure list of the articles found in the riverbank. While exhibit 1, I put my signature, while exhibit so and so on it. That much I know. Now, my lord, page 16, cross-examination.
Lordship, may I interpret one aspect regarding PW1 and 2 did not mention that they did not see Habibur. I have seen the order sheet. It's not reflected in the order sheet whether they were present or not. He was present or not. Accused persons, namely Abdul Hakim, Abdul Karim, it's an order dated 3/4/14 of the Larned Session Judge, my lord. Mia Hussain, Ajijul Haq, Sahid Ali, and Abdul Rahim are present. 2 PWs are present. They are examined, cross-examined, and teachers. No mention about Habibur, whether he was absent. And lordship, that's why the PWs didn't mention.
There has to be a reason, because if I'm brought from the custody, if for illness or for any other reason, if I'm not being able to be produced before the concerned magistrate, there is a reason to be required to be reflected, my lord. I cannot of my own volition choose not to attend on that day. And I'm not an absconder. That is an admitted fact. I have been in custody all throughout. That even the learned court below has recorded that the absconder is Muhammad Fakhruddin and one other person has died, accused has died. So there is no question of me not being absent and not being present. I'm required to be present. I will be made to be present, in fact. Well, page 16, cross-examination. I was not examined by the police. As such, any statement recorded in my name is not my statement. I do not know how and by whom the deceased was killed. The place where the dead body was buried about 1.5 kilometers from the embankment. The river bank is about half furlong away from the market. I did not see any identification mark on the seized articles, but the villagers opined that those articles belong to the deceased Ajipur. I have not seen the seized articles of court today. At the time of signing the exhibit, I was not aware of the content of it, and I signed on it on being asked by the police to do so. It is not a fact the accused had not made any statement before the villagers about the killing of the deceased and buried the body in the char. It is not a fact the accused lead the police and the villagers to the place where the body was recovered in the char. It is not a fact as stated before this court, but they are not correct and true. So, my lord, he says that I do not know who and by whom the deceased was killed. So basically, his statement, again, as stated, he is dependent on the PW2. He is all learned hearsay. He has all learned, whatever he has learned from basically the villagers and PW2. And page 17, the further cross. Matikula Bazaar is at about distance of 1 furlong from my house. I know Rumena from before. She's related to me by village courtesy. When police came to Matikula Bazaar for investigation, I went there. Rumena did not go there with me. I did not find Rumena at Matikula Bazaar when police came there. So he says, I did not find Rumena at Matikula Bazaar when police came there. Rumena told me that Habibur and Azizul had called away her husband. It is not a fact that is false that accused persons confessed that they called away Rumena's husband Azizul, killed Azibur and kept his body buried. It is not a fact that it is not true that Azibul and Habibur showed the dead body by remaining present at the time of digging it out. The words used here, my lord, that Azizul and Habibur showed the dead body by remaining present at the time of digging it out. So he does not say that they dug it out. He says they remained there at the time when it was dug out. Now, my lord, at page 19, there's a deposition of the PW4. PW4, before he has stated that many other people, from first line I'm reading, my lord, for first line page, the line prior there too. So he takes the name of people and many other people were present when the accused duo confessed their guilt. On being informed, police came there and the accused persons were handed over to the police.
You're reading from?
My lord, page 18, last line. I'm not reading the names of those people. He has given names of a lot of people. Last line, Abdul Kasem Foreji and many other people. I may read from the first line paragraph itself. Otherwise, there may be some difficulty in knowing what he's saying actually. The incident took place on 14/4/2008. He is again saying about 14/4. So it's 13 or 14 again. On the day of the occurrence, I was standing at the gateway to my house. Then I heard from Jahangir that Azibur had been killed and that 2 persons were detained by the public at Matikula Bazaar. So he is also saying that 2 persons are detained by the public. Getting the information, I went there and saw that Azizul and Habibur were kept detained in the pharmacy of VDP Secretary Afzal Khan. I saw around 200 people gathering there. So 200 or 500, there were hundreds of people gathering there. No police, they were detained by the public. On being asked about the incident, Azizul and Habibur said that both of them, along with so-and-so, and some others had killed Azibur. Now, Jahid Ali, Javed Ali, Asmat Ali, Jainal Abdin, Mazibur Rahman, Government Gaubura, Nurul Islam, that is PW1, Abdul Qasim Faraji, and many other people were present when the accused duo confessed their guilt. On being informed, police came there and the accused persons were handed over to the police. When the police again interrogated the accused persons in the presence of the public, both the accused persons confessed in similar fashion. So there is a second confession. Taking along the accused duo, police went to the place where Azibur was killed and having found muffler, sandal, and bicycle lying at the place of occurrence, police seized the same. Blood was seen in the drain of Boro paddy cultivation. It's talking about blood. You know, if the blood was there, stands to reason that everybody would have seen the blood. Everybody would have mentioned about the blood. At least those people who had seen the muffler, sandal, bicycles, they would have seen the blood too. So my submission here at this moment is, if the blood was there in the drain of the Boro paddy cultivation, so apparent on the face of the record, either everybody knew where the blood trail led and where the dead body could be possibly found. This was a public place, my lord. It has been reiterated that this is a road, common road, used by everybody, villagers, to leading from their house 1.5 kilometers away to the embankment. And blood is there everywhere in the paddy cultivation. Thereafter, Azibul and Habibur led police to the place where Azibur was kept buried after his murder. Jute seeds remained sown in that place after arrival of the magistrate. Azibur's Rahman dead body was dug out. In the course of the investigation, police recorded my statement. The land having Boro paddy cultivation is about 0.5 kilometer away from the pharmacy. There were 200 bighas of land having Boro paddy. That place where the dead body was buried was about 0.5 mile away from that place. That plot was an agricultural land, and around that time, jute seeds were sown thereon. Police did not record any statement when the accused persons confessed that they would show the place. So, my lord, there is no confession that the accused knew the place and they were going to show the police where the body was actually buried. Which ties in with section 27, because for that to discovery, they must explicitly tell the police that this is there, we know where the body is buried and we can take it there. That has to be performed part of the confession. At first, I came to know about this incident from Jahangir. Jahangir is alive now. It is not a fact that I did not state to police I heard from Jahangir that Azibur had been killed. It is not a fact that I did not state to police that there was blood in the drain of Boro paddy cultivation and the bicycle, muffler and sandal were lying there. I did not notice whether police brought the blood-stained soil. It is not a fact that I did not state before police that when both the accused persons were making confessional statement, Jahid Ali, Javed Ali, Hasmat Ali, so and so, were present there. There was a commotion due to delay in the recovery of the dead body of Azibur Rahman, and owing to that, the police registered a case against the public, and I too wasn't accused of this case. So PW4 is again, he has been made an accused. He can, in no stretch of imagination, can be said to be a witness, independent witness who could not be influenced by the investigating agency. Man. 2 witnesses till now, others are also there. Most of the witnesses have been arraigned as an accused because of the fracas. So it is, my lord, may turn to the second last paragraph. I saw around 500 people outside the pharmacy of Afzal. So there is pharmacy where the public detention and interrogation was going on. 500 people, he says, they were around there. I did not see if the public had assaulted Azizul and Habibur. Having seen the muffler, sandal, bicycle and blood at a place about half kilometer away, some people requested the police to visit that place. As per request of the public, police visited that place. This is the final nail in the contention that the accused were the only people who could have known where the bicycle, muffler, sandals were, where the blood was. This is basically people had told the police that these articles are lying on the embankment, the blood is there, kindly go there. And the accused happened to be taken along on the way. So this statement proves that fact. The chain of events is actually an alternate chain of events, not the one that the prosecution has tried to establish. My lord, now deposition of PW5. PW5 is one Afzal Hussain Khan. My lord, if in order to make it shorter, my lord, I have to state it in PW5. PW5 has given 2 contradictory statements. One that taking along the accused duo, police went to the place where the dead body was buried. Secondly, he later says that the accused led the police to the spot. That is at page 22. I know if I were there, page 22. He is the VDV secretary, so my lord, I believe his testimony would also be of importance because he is one of the persons who stated that who told that he informed the police about the occurrence. So my lord may turn to page 21. I'll read the entire deposition. Page 21. I know the accused persons. Accused Habibur Rahman hails from village Romari. Rest of the accused persons are from village number 2, Khandulimari. Now, my lord, this is the first query I raised myself. Everybody till now has stated that PW1 and PW2 in particular have stated that those accused persons are from my village, their village. He is the one person who states accused Habibur Rahman hails from a village Romari. I am from a different village. And if my lord will recollect, the same contradiction had cropped up in testimony of PW1 and PW2. They were talking about a person Hobby. So here, my lord, he says, my client Habibur Rahman, the convict herein, appellant herein, he hails from a different village. All the rest are from the village, same village as the accused, as the deceased victim. And indeed, all the PWs. I know informant Rumena Khatun, I knew deceased Azizur Rahman. Azibur Rahman, he was the husband of the informant. The incident took place on 14/4/2008. At the time of occurrence, I had been the VDP secretary of village number 2, Khandulimari, and at the pharmacy at number 2, Khandulimari Bazaar. He is the owner of the pharmacy as well. So on the day of the occurrence, when I came to open my pharmacy, Rumena told me that around 8 p.m. on the, again 8 p.m. on the previous night, my lord, will note. The timing has changed. Azizul Haq and Habibur called away her husband Azibur from home. They called him away to collect their wages. This is again a difference. One is for earth filling. Here he says they have come to collect their wages. That night, Azibur did not return home. Then many people gathered at the market. Then we, the members of the VDP and the villagers, went to meet Azizul and Habibur. We found them and brought them to my pharmacy and questioned them. Then Azizul and Habibur confessed that they both, along with Jahid Ali and Fakhruddin, had killed Azibur and buried his body. I informed the Deng police station about the incident over phone. Police came to the place of occurrence and we handed Azizul and Habibur over to the police. Taking along the accused duo, police went to the place where Azizul was buried. Later on, says, the accused duo led police to the place where Azizul was buried. So there are two statements given. He first says, taking along the accused duo, police went to the place where Azizul was buried. Later on says, the accused duo led police to the place where Azizul was buried. So two statements made immediately one after the other. One he says he went along with them. One he says, no, he took them to that place. Later on, the accused persons led police to the place where jute seeds were sown on the other side of a dead channel of river and showed the place where the body of Azizul was buried. OC said that the dead body would be exhumed after arrival of the magistrate. After arrival of the magistrate, Azizul's dead body was exhumed. Police took the dead body away. Now, Azizul and Habibur were brought from the front of Azizul's house. The distance between Azizul's house and my pharmacy is about 400-500 meters. The place where the dead body was recovered is about half kilometer away from my pharmacy. I was present there from the time the wife of the deceased told me about the occurrence to the time of the recovery of the dead body. Police did not record statement of any accused or witness in between the time of making confession by the accused persons and the time of recovery of the dead body. So again, he says that there is no confession of any by the accused person regarding recovery between the time of making confession and the time of recovery. So no confession leading to recovery. Police did not write anything regarding the confession of the accused persons before police. So, my lord, this was not written down. Police had not written anything regarding the confession made by the accused persons before the police in front of the public. All this is oral. It is not a fact that making of confession by the accused person before police and us showing of the place where the dead body was recovered by them is not true. Jahid Ali, Abdul Qasim, Abdul Fareji, and village headman Nur Islam came after the accused persons were brought to my pharmacy. So PW1 is stated as having come to the pharmacy after the accused persons were brought there to the pharmacy, which he says that I had gone to visit the house of the PW2, but on the way I saw that I came to the pharmacy and the accused persons were being publicly detained there at the pharmacy. Whatever police did after coming to the place of my occurrence on receipt of my phone call were done on the basis of my phone call. So he states that he is the one who has informed the police and they came to the place of the occurrence after he had informed them and they did on the basis of his phone call. He says, I don't know when the FIR was lodged. Police questioned me. It is not a fact. I did not tell the police that Azizul's dead body was recovered at jute field, situated on the other side of the red channel of the river. As the arrival of the magistrate was delayed, a violent situation occurred between the public and the police. Look, I fail to understand why the arrival of the magistrate would be delayed, because the arrival of the magistrate would come only after the recovery has taken place. They have dug up the body and discovery has taken place. So that arrival of the magistrate was delayed. A violent situation occurred between the public and the police. Police lodged the case against the leading persons as they tried to attack the police. About 4,000, 5,000 people gathered at the place of occurrence. Well, this appears to be a large affray. Possibly 400, 500, maybe a zero is added, but this is a large affray. And again, this police has registered case against 7 people, including Abdul Qasim Fareji, Abdul Qasim, village headman Nur Islam, Inamul, and me. So, my lord, if I look at the list of witnesses, PW1 is also a place, he's the headman. He has been named as an accused in the case lodged by the police. PW2 is of course the victim's wife. PW4 has admitted that he's also one of the cases. Then PW6, PW7 as well, I believe. Most of the witnesses, they have cases pending against them at the time of this trial. And afterwards, they were acquitted. Everyone was acquitted in that case. So it beggars belief as to if there is an affray and there is attack against the police when they try to discharge their official duty, why no one is found guilty? Now, my lord, after exhuming the dead body, police wrote something. I did not put my signature on that paper as witness. It is not a fact that accused Azizul and Habibur neither confessed that they killed Azibur and buried him, nor they showed the place where the dead body was buried. It is not a fact that I was not present at the place of occurrence from the beginning. The dead body was taken away from the place of occurrence within 2 p.m. to 3 p.m. on the day of occurrence. Police came to my pharmacy within 7 a.m. to 8 a.m. after getting my phone call. Informant was with the police from morning till the recovery of the dead body. I did not see if the police had obtained Romina's signature during that period. During that time, I didn't see whose signatures police obtained. Having found muffler, sandal, blood, bicycle, etc. lying at a little distance from the place where the dead body was recovered on the other opposite side of the dead channel of the river, the villagers raised a furor and informed this to the police who came near my pharmacy. It was 8 a.m. at that time. That this is important. So basically, everybody knew it was open knowledge of those articles, blood, everybody. I did not hear what the police replied after hearing about the blood and sandal lying there. It is not a fact. I have adduced false evidence against the accused persons. Getting the information of the muffler, sandal, blood lying there, police went there. At the time, accused Azizul and Habibur were also with the police. Now, my lord, this is Abdul Qasim Farezi. This is he's also, I believe, PW6 is also one of the witnesses named in the other FIR lodged by the police regarding the affray accuser. I know all the accused persons. I know informant Romina Khatun. I know deceased Azizur Rahman. We are fellow villagers. The incident took place in the year 2007. 2007. In the morning on the day of the occurrence, I came to my shop at Matrikula Bazaar. Then Romina Khatun came and while crying, told the people in the market that last night Azizul and Habibur called away her husband from home and that her husband did not return home thereafter. Then we, the VDP secretary, so-and-so, Abdul Qasim Master and many other people went to Romari village from the market along the embankment. While passing along the embankment, we saw a bicycle, a pair of sandal and muffler lying at the side of the embankment. We also saw blood there while passing along the embankment. Then Azizul and Habibur also came there. They came there of their own volition. They were not, asked to. They were not wanted. They were not dragged. One version says that they went to Azizul's house and brought the accused from there. Then they took him to the pharmacy. Now this version says that Azizul and Habibur came there. VDP secretary and other members of the BDP brought Azizul and Habibur to the pharmacy of the VDP secretary. On being questioned, they admitted that they had killed Azizur Rahman and buried his body at a place. Then on being informed by VDP secretary, police came there. On being interrogated by the police, they admitted their guilt and led police to the place where the dead body was buried. He says he led police to the place. I too went there. A large number of people went there. The said place was plowed for jute cultivation. That was a charred alluvial land area. Police called the magistrate. After arrival of the magistrate, police examined the dead body. Police questioned me. I was present when Azizul and Habibur were caught by the public. Were caught by the public, man. They were caught. The word use is significant. They were caught, apprehended by public at large. I was at the market when police arrived. I cannot say whether the police recorded the statement of Azizul and Habibur after they had admitted their guilt before the police and before they led police to the place where the dead body was buried. Fazur, Abdul Qasim Master, Iqbal Hussain, Kabir, and many other people went to the place where the dead body was buried. Around 4,000, 5,000 people gathered at the place. He also says 4,000, 5,000 people. where the dead body was buried. The place where the dead body was buried is beside the river. During summer flood occurs here, during winter, people cultivate this land. These are my procedure. It is not a fact that I did not state to the police that Romina came to the market crying and told the people that her husband had not returned home. It is not a fact that I did not state to the police that I, along with Kasim Master and many others, went to village Romari along the embankment. It is not a fact I did not state before police that Azizul and Habibur came near the embankment. So he reiterates that they came. They were not taken from their house, they came to their on their own. It is not a fact that accused Azizul and Habibur did not confess before police and asked that they had killed Habibur and buried him. Many people gathered at the place where the dead body was buried, and the agitated people assaulted the police, my lord. Words used are significant. All of these witnesses, they were arraigned on charges of assaulting the police. None of them were convicted. All of them are, most of them are interested witnesses in this case. And agitated people assaulted the police for the delay in the arrival of the magistrate. My lord, interested meaning thereby without any making any allegation of some kind. I only intend to convey the fact that these witnesses had the pressure of a case pending against them, a serious charge of assaulting the police. Whatever be the cause may have been, their justified grievance for delay of magistrate, there was an assault on the police, impediment on the performance of their duty, official duty. Therefore, that again, it becomes unbelievable as to how nobody was convicted in that. All of them appear to have been acquitted in the trial. And they have also come here to depose that the police, initially they were told by the villagers that where the dead body is lying or where the blood is there, where the articles are there. Then all of them changed their statement to say that the police, the accused led the police to the place where the dead body was there. My house is at number 2 Kandli Mari. My house is about half kilometer away from that of deceased. When I visited Romari village, I personally did not ask anyone about the occurrence. Azizul and Habibur are from village Romari and deceased was from number 2 Kandli Mari. So again, he says that Azizul and Habibur are from different villages. In fact, he even says Azizul, one person has said that Habibur is from, my client is from a different village. He says that even the other accused, Azizul and Habibur are from village Romari, different village.
Just come to page 26.
Yes.
Last.
Line. It is not a fact that accused Azizul and Habibur did not confess before the police and us that they had killed Habibur and this is a mistake. I mean. This is not Habibur. This should be Azibur. As this deceased is Azibur. It's a typographical error. Deceased is Habibur.
We understand. Is it in English or Bengali?
It's in vernacular, Mike. Lordship, it's read as follows, my lord. সত্য নহয় যে মই পুলিচক আগত কোৱা নাই যে আইজুল আৰু হাবিবুৰ মথাউৰিৰ কাষত আহে। সত্য নহয় যে আসামী আইজুল আৰু হবিবুৰে আমাৰ আৰু পুলিচৰ আগত স্বীকাৰ কৰা নাই। তেওঁলোকে হাবিবুৰক মাৰি পুতি
He's saying
So
Habibur.
they say they have not, it's not a fact that they have not stated, Aijul and Habibur have not stated before the police regarding তেওঁলোকক হাবিবুৰে মাৰি পুতি থৈছে।
So that error is
Habibur has
there.
killed and buried it.
Yes, that error is there in the deposition as well. They do not know that they had killed Habibur. So that error is there. Material error is there. So who are they talking about? Whether Azibur, if I may look at the in the examination in chief, he says that he knew deceased Azibur Rahman. He knows the deceased name Azibur Rahman, Vidibul Hazibur Habibur on being questioned. And in the at page 26, first line, on being questioned, admitted that they had killed Azibur Rahman. So twice he writes Azibur. Here he writes, denies, says that he says they confessed that they had killed Habibur. Now, that may be a problem, my lord, because if he is talking about two different persons, it presents a problem. He says he knows and he refers to the correct name correctly. So whether the question put to him was erroneous and he merely used the name, that is difficult to know. My lord may move from this for time being, may not be particularly relevant. PW7 is important because this PW is the one who says, my lordship will recall, that this was the, we had said at one time that the accused were taken to a room about with 50, 60 people, and there they were interrogated while the thousands of people waited outside.
Who's PW7?
PW7 is another witness who is also named in the, I believe, the FIR. Iqbal Hussain Kabir, he's also person who learned about the occurrence from the PW2. So I know all the accused persons. I know informant Rumena Khatun also. I knew deceased Azibur Rahman. He was husband of the informant. The incident took place in 2008, around 6 a.m. on the day of occurrence morning, when I was coming out from the masjid after offering namaz, moment prayer or worship to God. Rumena Khatun told me crying that last night Habibur Rahman and Azizul called away her husband from home, but he didn't return home till the morning. Then other people also came to the place where the masjid is situated at Matikula Bazaar. Hearing Rumena, when the public asked her where her husband was taken to, she said that he was taken towards the embankment. Then we people went near the embankment and saw a blood-stained shirt, a pair of sandals, and a bicycle there. Then we went to the house of Habibur and Azizur, and finding them at their house, we brought them to the bazaar. They were brought to the pharmacy of the VDP Secretary Farazi, the previous PW6. On being asked about Azibur, Habibur and Azizul admitted that they had killed Azibur and buried his body, and Fakhruddin, Abdul Karim and another person were with them. Then we informed Ding police station about the incident and police came. Habibur and Azizul admitted their guilt before police and they said that to show the place where the dead body was buried. Police called the magistrate and Azibur's dead body was exhumed from Chapori after the arrival of the magistrate. During the investigation, police questioned me. In cross, the house of the deceased is about half kilometer away from the masjid. Matikula Bazaar is apart the house of the deceased. The masjid is situated at the center of Matikula Bazaar. About 150 people were present in the masjid when Rumena was telling about her husband. Houses of accused Habibur and Azizul are also half kilometer away from the masjid. We came to know from Rumena that last night Habibur and Azizul called away her husband, and we did not know about the occurrence prior to that. Habibur and Azizul admitted inside a room that they had killed Azibur. At that time, about 50 to 60 people were present inside the room and thousands of people were present outside. This is a mass inquisition. And police did not record the statement of me and other witnesses present in the room. So there is again a material deviation that not thousands of people or hundreds of people did not hear it. 50 people took him separately inside the room and they did the actual interrogation. They heard the confession. So police did not record the statement of the other witnesses present in the room when Habibur and Azizul confessed before police that they had buried Azizul's dead body, and they would show that place. The place where the dead body was buried is an open area. Place where shirt, sandal, bicycle were recovered is about 1 kilometer from the place where the dead body was buried. I did not see the blood-stained shirt, sandal, and bicycle properly, and did not notice any special mark or identification marks. Such things are available in every household. It became too late in exhuming the dead body. And therefore, the villagers got agitated and they were about to attack the police, and 1 or 2 police officers got injured. Again, my lord, this is not the seriousness of the incident cannot be downplayed. There was injury. And in order to protect themselves, police moved a bit away. Seeing the violent situation, police registered a case against the leaders in the public. Those who took the lead in the affray, their case was registered against them. I was also an accused in that case. I was acquitted after the trial. There were 8 accused persons with me. It is not a fact that accused Habibur and Azizur neither confessed their guilt nor led police to show the place where the dead body was buried. It is not a fact that accused Habibur and Azizur did not state that Fakhruddin, Abdul Karim and another person also committed the incident with them. It is not a fact that I did not state to police that when I was coming out of the masjid, Rumena was crying and saying before the public that in previous night, Habibur and Azizur called away her husband. It is not a fact that I did not state in the statement given to the police that after hearing Rumena, we the people went to the embankment and we saw the shirt, sandal and bicycle lying there. Thereafter, we went to the house of Habibur and Azizur, and having found them in the house, we brought them to the bazaar. So this is another contradiction with the previous witness, PW6, if my lord will remember. He said they came there. Now he's reiterating on a suggestion being put to him that no, they did not come there. We went to their house, we took them from their house and brought them to the pharmacy. It is not a fact that I have adduced false evidence during the occurrence of the OC of Ding police station with Datta surname was there. Rumena Khatun was with us when we went to the embankment of the masjid. I did not notice if she was there with us thereafter. Though I was present when police seized shirts, sandals and bicycle, police did not take my signature in the seizure list. I cannot say whose signatures were taken. I cannot say whose signature was taken by police at the time of recovering the dead body. The distance between Matikula Bazaar and the place where the dead body was recovered is about 1 kilometer. Rumena did not tell us why her husband was called away by Habibur and Azizur. It is not a fact that involvement of other accused with Habibur and Azizur is false. So, my lord, these concludes the depositions of PWs 1 to 7. At the risk of repetition, my lord, I'll just summarize what PW 1 to 7 basically what I intend to state with regard to my client. Now, PW 1 says accused Hobby is not within the dock. That is at page 8. He says accused Hobby is not within the dock. He's declared absconder. I was never declared absconder. I was in the, whether I was in the, if I was not in the dock, there has to be a presence recorded that so and so accused is not in the dock for such and such reason. Otherwise, the court would naturally ask, why is that person not in the dock if he's in custody? Or if he's out on bail, then there would have to be an adjournment or a petition stating the reasons for non-appearance. When all the other accused are in the dock and I am not in the dock. And here PW1, the village headman is saying that Hobby is not in the dock, he is declared absconder. Now, regarding the, he is also the number 1 PW, he is the headman, he is the leader of the fracas. So there is a case registered against him by the police. He is acquitted in that case. So my submission is that he cannot be said to be totally non-interested witness in this matter. In any case, he does not have personal knowledge of the facts he's deposing to. He's admitted that he has heard everything he knows. The statements he has made because of the version given to him by PW2, the wife of the victim. The wife of the victim at various points states that event took place at 6 o'clock, at 7 o'clock or 8 o'clock. My submission is that irrespective of time, it is clear that it was dark because the lamp was used. There had to be, she said that she knew the faces of the accused because they were all from the village. Now, I am not from that village. That is again established. I am from village Romari. They were from number 2 Kanvlimari. So that is a false statement there. Secondly, there is no identification ever done specifically stating is so and so person in the dock the accused Habibur Rahman or accused Hobby who led your husband away on such and such date at such and such time. There has to be a categorical identification because here names have been used interchangeably, as our lordship has noted. Names have been used shortened, somewhere they have been shortened, somewhere wrong names have been attributed. It was incumbent on the court to identify who were the actual persons who led the accused away on 13/4/2008 and what was the time when it was led away. That was not there. Now, she has also resigned from the fact that there was any quarrel or dispute. That part has also been resolved from inner cross-examination. And there is no evidence as to who wrote the Ejahar at all. PW2 says she wrote it. Thereafter, she says that no, the police wrote the Ejahar. Then she says he doesn't know who wrote the Ejahar. Nobody else has given a clue as to who wrote the Ejahar in the file. Now, so far as PW3 is concerned, these PW3, 4, 5, 6, they mainly concentrate on the fact that there was a recovery of muffler, comforter, slippers, and bicycle in the riverbank, along with blood there. But as I've shown before, Lordship, this was known to the villagers prior to the fact of apprehending the accused. It was on a public thoroughfare. And everybody knew where the blood was. Around 150 people were even at the time of the masjid where the incident was told. The villagers went there, they saw the slippers, everything on the way, the blood on the way. And thereafter, a dispute arises as to the fact of whether the accused came to the spot and were apprehended, or whether they went to the house of the accused and apprehended them. Now, normally, these are kind of conflicting versions of events, which I would not press upon your Lordship very much. But in this case, where the Honorable Trial Court has already set aside the fact of discovery, has declined to treat this fact as a discovery. And your Lordship has seen that hundreds of people literally are aware of the site where the dead body possibly could be. The question of arriving that only these two people knew where the dead body were buried, that does not seem to be a very tenable finding on facts. Now, my lord, in this case, 3 and 4, 5 and 6, 7 also, most of these are cases have been registered against them. They are also acquitted. Nobody has been convicted, even though this is a case where there is an assault on police personnel and police personnel were injured. And they knew who had done it. And all of them, basically 3 to 7 and 1, their only purpose has been to bolster the testimony of PW2 that, yes, we apprehended the accused, an extrajudicial confession was obtained from them, and that extrajudicial confession was again verified in front of the police, again in front of the public. Now, the learned trial court has gone into one aspect of the matter, whether there was a forceful confession, and declined to say that there was forceful confession. But in light of the fact that there were thousands of people, at least 500 people outside the pharmacy, and thereafter they were interrogated by the public before the police came, well, I do not believe that voluntary extrajudicial confession holds much water. In fact, I would suggest, my lord, that for fear of incurring mortal harm, possibly the accused said whatever the villagers wanted to hear. Because there is a testimony there, PW6, that says that they asked the accused, when they came to that, they asked them about what happened to the accused or deceased Ajibur. They were charged because the PW2 told them that previous night before, Habibur and Azizul had taken, along with some others, had taken her husband away. So there was a story in the minds of the villagers that she was crying. That fact is also borne out, that she was crying in distress. Villagers were agitated, and they took those two people and asked, what have you done with the deceased? Took them to the pharmacy to interrogate them. Now, my lord, that story appears to be plausible. Question of whether such an interrogation, the confession arrived at after such an interrogation, can be relied upon. And in particular fact of my client, where there is his identity has not been established as being the one who led away the deceased on 13/4/2008 in the afternoon or in the evening. If my lord takes this PW2, the crux of the testimony is PW2. So PW2 is Rumena. Again, I reiterate, in her examination in chief says, I know all the accused persons, they are from my village. She says it. I am admittedly not from a village. I am from a different village. The PW1, the same problem with accused Hobby not being in the dock. Accused Hobby not being in the dock is reiterated by PW1, and PW1 also says, if my lords will turn, PW1 at page 8, he also says, I know all the accused persons by name. They are my co-villagers. Now, being the village headman, the least thing expected from the village headman would be to know who his co-villagers are. He should have said, rest are my co-villagers. Habibur is from village Romari. That should have been the first statement out, falling from his mouth. So he says they are all my co-villagers. And this interesting fact of that accused Hobby not being there on the dock, this is repeated only for PW1 and PW2. So my submission is that, my lord, identity of accused Hobby has been wrongly attributed to me. Perhaps there is an accused Hobby who led the deceased away on the evening of 13/4/2008. But for the fact that a question having never been put to the PW2, that is this accused Hobby and Habibur Rahman the one and the same person? Everybody took it for granted that Hobby was a shortening of the name Habibur, which is normally usually the case. My lord will never find a testimony that any statement has been made are accused Hobby and Habibur the one and the same person. Nobody has ever bothered to put that question. So therefore, my lord, my submission is that there is sufficient doubt to grant the benefit of doubt to the accused convict in this case. And he has been in custody since 2016. That is without, my lord, the rest I leave to your lordships.
This is the postmortem report.
My lord, I'm sorry, my lord. I would like to postmortem report. There was a postmortem report. If my lord, I'll read the postmortem report, because there is one aspect of this that perhaps 86, page 86. Postmortem report 18/4/2018. Date of station BPCH Nagaon, day of 15/4/2008, namesake agent caste, Mohammad Ajibur Rahman, male, 35 years, Muslim, whence brought village and Thana, son of late Karamat Ali, son of number 1, Kandulimari, PS Dean. Name of constable, so date and hour of dispatch is 14/4/2008, arrival at Dead House 14/4/2008. Examination, then information as per now, my lord. External appearance. Condition of subject, stout, emaciated, decomposed, etc. Dead body of a male, aged about so and so, average build. Whole body, surface covered and containing sands, bought for PM examination, rigor mortis absent. Now, my lord, there's a certain argument which I wish to make, whether it finds favor with your lordships or not, on the question of rigor mortis. From this, I had taken an author of ENT and head and neck surgeon reviewer in the what are the stages of rigor mortis? There are 6 stages of rigor mortis. Now, forensic use, the word forensic use of rigor mortis is in an unusual position, is a confirmation of 2 facts. My lord, when there is a rigor mortis, the word here, rigor mortis, here is used as absent. If my lord comes down to page the 161 statements, 161 statements of the accused. 161 statement of the 161 statements of the accused and the Azizul Haq, accused of the Azizul Haq. The body was moved at the murder, page 94. 94, page 94. 92 to 94. 92 and 94. This is the statement of accused Azizul Haq. My name and address are as given above. I am aged about 19 years. Regarding this incident, I have much to say this. For some days, Habi Azizul, Fakhruddin, Syed Ali, Abdul Barik were doing art cutting work at village Romari. Fakhruddin, Qasim, Syed Ali, Hakim have old dispute with Azibur. Out of that grudge, yesterday on 13/4/2008, the said persons told me and Habibur that they would kill Azibur in that very night, and that Habi and I had to call out Azibur from his residence. They made a threat that otherwise they would kill us too. They told that after calling him, we would have to take him to the embankment of village Romari. They would keep hiding there, and as soon as we would reach the embankment of village Romari, they would attack and kill Azibur. Accordingly, at about 8 p.m. last night, Habibur and I went to the residence of Azibur and falsely telling him that we had to collect wages for earth cutting, took him with us to the village Romari on bicycle. As soon as we two, along with Azibur, reached near the embankment, Fakhruddin came with a kukuri and Syed Ali came with a sword. And A. Qasim came with a dao from the place where they were hiding near the embankment. It was planned earlier. Suddenly attacks went to Azibur by means of weapons there in the hands, and this caused the death of Azibur. After Azibur had died, we took his dead body to the land of Fakhruddin's border and buried it there following a discussion. Land of Fakhruddin's brother and buried it there following a discussion. When Azibur didn't come back to his house the morning, he was searched for and people recovered his bicycle and sandal near the embankment. And when Habi and I were coming towards the market, people apprehended and questioned us. We confessed before the public that we killed Azibur and kept his body buried under earth. Later on, we led police and showed the site where the dead body was kept buried. People of the village dug out the dead body. Now, my lord, if I treat this to be true, assuming I treat this to be true, their dead body was moved. Dead body was moved. Now, if the body is moved after murder, and this would have led to rigor mortis in an unusual position. Unusual position meaning that by rigor mortis develops, body stiffens, it is in a normal position. An unusual position would mean where hands, limbs are in an unnatural position. When the body is lifted after death, kept somewhere else, this leads to rigor mortis in an unusual position. This is, of course, research which I did on my own. The use of rigor mortis in an unusual position is in furthering the investigations and scientific confirmation of two facts. Scene of death occurrence is different from the scene of disposal of the dead body and the time gap between two places. When there is a difference on time gap between the death and the disposal, partial rigor mortis sets in. Before it has fully set in, if the body is moved, then again, an unusual, if the body is dumped, for example, in an unusual position, the rigor mortis sets in that position itself. That is called development of rigor mortis in an unusual position. Now, in this case, in the post-mortem report, rigor mortis was absent. Not in an unusual position, not in an usual position. Rigor mortis is absent completely. It has gone. So my point here is that if the body had been moved after murder, as has been stated here, if the body had been moved, there would have been rigor mortis in an unusual position.
I'm sorry to say it's not admissible, my lord. Misstatement made.
I'm just pointing out an scientific fact. And this is exhibit 5. This is exhibit 5. My lord, this is where from in the point of living in, and another further point, my lord, page 94 is the statement of my client. My 94, page 94 is a statement of my client. This is almost verbatim. Same. My name and address are as given above. My name and address are as given above. I'm aged about 19 years. I'm aged about 19 years. Regarding this incident, I have to say that Azizul Fakhr so-and-so, I together do art cutting work. In the evening of so-and-so, A. Hakim, Fakhruddin, A. Barik, Syed Ali told Azizul that they had to kill Azibur. That Azizul and I were to call out Azizul from his residence in the night. We were to take him near the embankment. They would be hiding near the embankment and they would be to kill Azibur as soon as he would reach there. This is verbatim. They made a threat to us that otherwise they would kill us. Same threat is repeated, my lord. And at 8 p.m., In fact, my lord, the accused refers to the site as PO, place of occurrence, which is not a term which a normal layman would use.
Mr. Barua,
Yes,
you are saying that this Habibur belongs to Romariville.
Romary village.
Page 92 says otherwise.
Page 92, Kandlimari. Ajijul is Kandlimari.
Page 94, 96.
Page 94, statement of both are Kandlimari. my lord. That status is given, but I am from village Romari. It is given as number to Kandlimari. My lord, I am saying that this statement is not by me. This is verbatim. Two statements have been given verbatim, and they have written the place of
161 statement. Okay.
161 statement. 161 statement. It was exhibited, man.
Lordship, even if it is exhibited, my lords, 161 statement, it's for under 172 CRPC, my lord, just for aiding your lordship.
My only point is that two statements have been doctored, made to look a separate, clear, identical version of events. And even the word place of occurrence is written, which is not a word which is not a layman would use. These statements clearly show that the intention of the prosecution was to establish a story wherein two people were shown to have led the accused out of his house and others participated in his murder. And thereafter, the dead body was disposed of at, he was killed in the embankment. The dead body was displaced around 500 meters away from there, which again I have placed before lordship that it cannot be done. Scientifically, there would be traces of that. So therefore, my lord, my statement is that the prosecution has failed to move its case because motive is absent. Motive has been disowned by the principal witness. The identity of person who took the deceased has not been established. Under such circumstances, my lord, the conviction could not have been established with any degree of certainty, my lord. That is my submission. And that is why, my lord, the issue of the timing of 6 p.m., 7 p.m., 8 p.m. comes into significance because in the theory of last seen together, if such a wide range of times are there wherein any of the accused are seen last with the deceased, my lord, on a public thoroughfare, then that question of the certainty of there being the only person last seen together with the deceased decreases with the range of time as specified by the prosecution's own case, 6 p.m. to 8 p.m. The other aspects which are the weapon was never discovered, that bicycle, etc., were not seized. These are technical points, my lord. These are technical points that I have to submit. Discovery of the weapon was not. The weapon was never found, in fact. So they have stated that if bicycle, for example, my lord, if the bicycle, the seizure, it talked about the muffler, sandals, slipper, and the bicycle was actually not seized by the police. There is one statement. Page 83. My lord takes up the page 83. This is seizure list, postmortem entry, GD entry statement in person. Sketch map of place of recovery of articles, my lord, but seized materials at page 84, my lord. One old cycle of Hero brand, which is a half hour, which is 24. These were seized, these were never exhibited, but there is a testimony of another witness as well, which states that the bicycle was never seized by the police. I'll take that. I'll take that. Testimony of one witness was there, if I may text. In fact, my lord, there is a mention there in PW7 states that there is a blood-stained shirt as well. That blood-stained shirt does not find mention in the list of the seized materials. In any case, none of these were exhibited, man.
This is all I have to say, submit before lordships.
Item number 12.
No, just being told that he will argue at a later stage. So, my accused Mia Hussain.
You are?
I'm for Mia Hussain, item number 12. My criminal appeal number is 21/22.
Arjita.
Arjita. Lordship, the evidences have been read out by my friend. So the initial submission that I had made, that my name surfaces only on 2 times. At the time when the FIR, page 4, Mia Hussain, he is accused number 7. And while he has been convicted. That is the judgment. He is accused number 3 in page 67. These are the only 2 occasions where my name has been shown. There is no other mention of my name by any of the accused. Even the statement at page 92 and 94, that they have not said the name, they have not given my name. What had possibly happened, Your Honor, all throughout the extrajudicial confession, if we assuming for a moment that it is admissible, all throughout the extrajudicial confession, we have seen that there are 2 persons, Azizul and Habibur. These were the main persons. If it is taken, if that is admissible at all. These 2 persons initially was taken into account, and from there that the other names have got. Because, Your Honor, here even Remuna Khatun, the informant, she also, the names of the accused, it is given by the police. Now, how my name has come, or the other accused, not just my name, the other accused like Sahed Ali or any other accused, how those names have come, this can be inferred from the events that from the events and their documents here. Now, what had happened is that as per Remuna Khatun only, she went to the village headman or anyone else, wherever it be. She said that there is an incident, my husband has not returned. Now, when this event happened, then they said, where is your husband? Some say that on the way they found the clothes. Some say that they came to know from that Habibur and Azizur. They had actually, she told the people out there that at night Habibur and Azizul had come. That is the real story. They had come. If at all, if it has to be taken to be true, because that was the initial thing. Even in page 92 and 94, 161 statement, if it is taken into it, because it is exhibited and that's why it is before Your Honor. Then they had come and they had taken out. Now, in their 92 and 93, they give names of everyone else. Sahed Ali, if Your Honor directly goes to 92, just to get an idea of the case, page 92, the names are Fakhruddin, Sahed Ali, Abdul Barek, Habi Azizur, page 92. So these other persons were made accused because these names were given by Azizul and Habibur. They said and this statement was taken at 14:4. So when the police interrogated that, as per, if the version of the police is to be taken true, when the police was doing the interrogation, they said out the names. But my name, Mia Hussain, it's nowhere there. It is not a single word has been said against me. Thereafter, regarding the
FIR. Now, FIR is just a initiation of an investigation. The FIR cannot be the encyclopedia, neither it can be the whole basis of the case. The FIR is just to start the investigation. So, Your Honor, this the witnesses of the statement of the IO has not been read out. I may be allowed to read the statement of the IO, which is at page 34. Page 34. On 14, Your Honor has got. On 14/4/08, I was the SI of police at Ding Police Station. Around 7:55 AM that day, VDP Secretary of Village number 2, Kandulimari, informed his PS over phone that a person was killed and the dead body kept buried. Here there is a big discrepancy. Here over the phone, they have already told that it is kept buried. How this information was to them, because they are saying that it was the accused, the other two accused took away. Now it said the information is that kept buried and that they detained 2 persons. Here it says 2 persons. Who 2 persons? Azizul and Habibur. Then OC SK Dotto and I, along with the staff, started off to number 2 Kandulimari, and I made Ding PS GD entry 219 dated 14/4/08 in this regard. Exhibit 4 is the GD entry book, and Exhibit 4.1 is a GD entry number 219 dated 14/4/2008. When we arrived at Kandulimari Matikula Bazar, we saw that many people had gathered there and that 2 persons were detained. The VDP secretary and the village headman handed over those 2 persons to the police. The OC entrusted me with the investigation of the matter. I interrogated the accused person and they said that they killed a person named Azizur Rahman and buried his body in the field, and they could show the place. The names of the accused persons were Habibur and Azizur. The names of the accused person were Habibur and Azizur. Specifically, the IO is telling. When we taking along the accused duo were going to the field, we saw an old hero cycle, a pair of leather sandal, and a violet color muffler lying near the embankment. Then Rumena Khatun, the wife of the deceased, identified all these things to be of her husband, and I seized these items in presence of the witnesses. Exhibit 1 is a seizure list, and Exhibit 1.3 is my signature. Exhibit 1 is a pair of sandal, and Exhibit 2 is the muffler. Thereafter, the accused person showed us the place where the dead body was buried. Exhibit 5 is the statement of Azizul Haq made before me. Exhibit 5.1 is the statement of Azizul Haq in such terms. Later, I went with the police and showed them the place where the dead body was buried. Exhibit 6 is the statement of Habibur Rahman made before me. Exhibit 6.1 is the statement of Habibur Rahman in terms. I led the police and showed the place where the dead body was buried. Thereafter, I informed the magistrate. After arrival of Ranveer Bora, the magistrate and circle officer Ding Circle, the dead body was exhumed as shown by the accused persons, and later on inquest was held on the body of the deceased. Exhibit 7 is the inquest report. Exhibit 7.1 is the signature of Ranveer Bora, the circle officer, which I am familiar with. I examined the witnesses. Later on, I sent the body for postmortem examination. I prepared a sketch map of the place where the dead body was recovered. Exhibit 8 is the sketch map, and Exhibit 8.1 is my signature. I prepared a sketch map of that place also where cycles, sandals, etc. were recovered. Exhibit 9 is the sketch map, and Exhibit 9.1 is my signature. I brought both the accused persons to the police station. Rumena Khatun lodged an Ezahar that day itself. On the basis of that Ezahar, Ding PS case number such and such was registered, and the OC entrusted me with the investigation. The exhibit 2 is the FIR, and Exhibit 2.2 is the signature of the OC Sushil Kumar Datta, which I am familiar with. Taking charge of the investigation, I questioned the complainant at the police station. I examined other witnesses also. I went searching for other accused persons involved in the case, but I could not find them. I arrested Habibur at the rate Habi and Azizul Haq and forwarded them to the court. Thereafter, I was transferred and handed over the diary to the OC. A cross on behalf of the accused Habibur and all accused persons. Sweeper exhumed the dead body at 1:30 p.m. The Ezahar was lodged at about 3 p.m. that day.
On the basis of GD entry, I visited the place of occurrence. I did everything, that is going to Matikhula Bazar, taking the accused person into custody, preparing the sketch map at the embankment, seizing the items, exhuming the dead body, holding the inquest on the dead body, and sending the dead body for postmortem examination on the basis of GD entry. I did not send accused Habibur and Azizul to the court for getting their confessional statement recorded in connection with their confession and their assertion that they would be able to produce the dead body that day. I did not record the statements of independent witnesses at that time where the accused person said that they would show the place where the dead body was buried. I had sent the dead body to the court for postmortem examination before I returned to the police station. I did not see the bicycle in the court today, which was seized by Exhibit 1. I did not seize the lamp in the gleam of which the wife of the deceased recognized the accused person. PW5 Afzal Hussain Khan did not state me that the Azizul's dead body was recovered from the jute field at the other side of the dead channel of river. PW6 Abdul Kazim Farji did not state to me that in the market Remuna Khatun cried and said that her husband had not returned. PW6 did not state to me that Kazim Master, he and many others came to the village Romari and that Azizul and Habibur came near embankment. PW7 Iqbal Hussain Kabir did not state to me when he was coming out from the masjid. Remuna cried and said before the public that in the previous night Habibur and Azizul had called away her husband. PW7 did not state to me that after hearing Remuna, they went to the embankment and found shirt, a pair of sandal and a bicycle lying there, and that thereafter they went to the house of Habibur and Azizul, and having found there, they brought them to the market. Rumena Khatun was present there at the time of recovery of the dead body. At 2:50 p.m., we took the accused person to the police station. Thereafter, the accused persons were taken to the place of occurrence. The time of preparing Exhibit 1, Caesar list is not mentioned in it, but in the diary, and it is 9:20 a.m. I did not maintain any other memorandum except the case diary for the investigation. I wrote 6-1 after the recovery of the dead body, though the case number is mentioned in Exhibit 1, but the case was not registered till that time. It is not a fact that accused Habibur and Azizul neither made any confession nor showed the dead body. Here also the IO, my name is not mentioned. Lordship, then be pleased to go to the charge sheet because that was not read through. The charge sheet, which is an important part of it. Page 102. It starts from 102. This here, my name is at 103. My name is there in the charge sheet. I stand corrected. My name is in 3 places: FIR, charge sheet, and the judgment. So 103, my name is at page at serial number 3. The relevant portion of the charge sheet starts at page 106. Page 106, yeah. Mary Love. The case in brief is that on 14/4/08, Mustafa Rumena Khatun, wife of late Azibur Rahman, resident of Kandulimari Gao, lodged and written Ejahar with the PS, alleging that yesterday around 7 p.m., her fellow villagers, 1 Fakhruddin, 2 Abdul Hakim, 3 Abdul Karim, 4 Abdul Rahim, 5 Azizul Haq, 6 Habibur Rahman, 7 Mia Hussain, 8 Syed Ali, all residents of number 2 Kandulimari Gao, PS Deng, called away her husband, late Azizur Rahman, saying that they had to talk to him. And he left on a bicycle and she recognized the accused person when she held the lamp when her husband was leaving. The lamp, which slide would have been, the diameter of the lamp would be how much? There are 7 persons, adult persons are there. So when one has to put up, so she sees all the 7 persons as per the FIV, it is to be taken on the value, face value. Accordingly, investigation was done on the basis of the Ezahar. Meanwhile, as her husband did not return, the informant informed the local people about the incident, and making an inquiry, the local people caught Azizul Haq and Muhammad Habibur Rahman, again no mention of my name, and handed over to the police station in connection with the incident. When interrogated, they confessed and And when they showed the place where the dead body was buried, Executive Minister Ranveer Bora held inquest on the dead body. The dead body was sent to BP Civil Hospital for post-mortem examination and report thereof and was collected. As per opinion of the doctor given in the post-mortem report, the deceased died due to excessive bleeding. A prima facie case of committing offense under section 302, 201 is disabling of evidence. 34 of IPC has been found against such and such. Here, absconding one accuses for forwarding. Therefore, I submit this charge sheet against the arrested as well as the absconding accused person. A certified copy, shown a seizure list is enclosed herewith. The witnesses mentioned in column 6 will substantiate the facts of the case. So even in the charge sheet, I have there is no mention of Mia Hussain. Now, Lordship may come to the judgment. What were the circumstances in the judgment which judgment starts at 67. We'll continue tomorrow.
Tomorrow.
Yeah. Second of single bench is there. But and Bora, amicus curiae in criminal appeal jail 94 of 2019. Also heard Mr. R.J. Das. Then a counsel for the appellant in criminal appeal jail 21 of. Also heard MSP. List for the hearing. Boris 31st. Deeply obliged. We'll continue tomorrow. So will be the first hearing item tomorrow. Yeah, obviously.
Lakshya, one more matter is fixed tomorrow, part third matter.
Okay, after that, this one. Any other matter tomorrow? Finish.
There is some error apparently on the face of record committed by the learned counsel on the other side, and one error in the as per records also. Your lordships, page 20,
Other side counsel.
he was available. 1 PM I informed her,
Last occasion also she was not there, isn't it?
and I informed her at 1 PM. At 2 PM it will be called. In the meantime, I'll proceed, Lordship.
Yes.
Judgment start from page 28.
That I think.
Prayer portion, Lordship may also look at that is also reflected whole prayer of the petitioners. Page 29. If you Lordship allowed me to read the whole judgment, it will be clear, Lordships. Page 29. The second line under the prayer, Lordship, the prayer of the petitioner, under circumstances displayed, dear to Lordships may be pleased to admit this petition, call for the records, issue a rule calling upon respondents to cause as to why a writ in the nature of mandamus and any other writ of like nature shall not be issued. Command the respondents to regularize the service of the petitioners against the existing vacant posts of grade 3, grade 4 posts, grade 4 of the board, and as to why a further direction shall not be issued, restrain the respondents for filling of the existing grade 3, grade 4 post through direct recruitment without considering the case of the petitioners, and as to why a further direction shall not be issued to the respondents to pay the arrear wages of the petitioners with effect from August 2013 and allow them to continue in service and causes being shown, and upon hearing the parties, be pleased to make the rule absolute, giving full and complete relief to the petitioners, and the first such other further order as the lordship may deem painful. Then, on the next paragraph, the learned counsel for the petitioner submits that the petition numbers 1, 2, and 3 were engaged as casual workers on compassionate ground on 1/12/2005, 10/1/2007, 1/5/2008, respectively. The petition number 4 was engaged as casual worker on 1/7/2007, as he has provided a plot of land measuring about 131 katas to the Brahmaputra board, Vasistha, Guwahati, with a request to provide him a job. Thereafter, in terms of engagement, the petition number 1 was initially paid rupees 1,900 per month, and the other petitioners were paid rupees 2,000 per month. The wages of the petitioners are subsequently enhanced to rupees 4,500 per month. The petitioners have paid their wages regularly till the month of July 2000. It will be 2013, Lordship, not 15. However, from the month of August 2013, the petitioners have never paid their wages nor provided any job, despite attending the office of the respondent board regularly. Therefore, the petitioner submitted a joint representation to the chairman, Brahmaputra board, Vasistha, Guwahati, Assam, respondent number 3, requesting release of honorarium salary. However, no positive response was received from the respondent number 3. Therefore, the petitioners have no option approach the Assistant Labour Commissioner, Central Government of India, Silchar, for taking necessary steps with regard to the engagement and remuneration of the petitioners. Accordingly, by letter dated 16/1/2015, the Assistant Labour Commissioner, Central Government of India, Silchar, wrote to the respondent 5 on the subject of non-payment of wages to the casual workers. In response to the respondent number 5, the respondent 5 replied by letter dated 31/12/2013, stating amongst others that due to non-availability of approval from the competent authority, the casual workers could not be engaged since August. That may be taken note in Lordship. Then it is also submitted that the respondent board submitted a report dated 4/7/2013 for engagement of contractual labor for various maintenance work under the establishments. However, despite submission of the report, no steps have been taken by the respondents. The learned counsel for the petition submits that the engagement of the petitioners number 1, 2, and 3 were made on compassionate ground, and therefore they have accrued a right to get preferential treatment in the matter of employment. It is also submitted that as the petitioner number 4 has provided land for implementation of the Amjud project under respondent board, with the understanding that the job would be provided to the petitioner number 4. Therefore, the action of the respondent is not engaging the petitioner 4 is arbitrary and without fair play. It submits that the petitioners have been serving the board for the past 7 to 8 years, and therefore they should be appointed on regular basis, and the direction should be issued to release their wages with effect from August 2013. Learned counsel for the petitioners has placed strong reliance on the report dated 4/7/2017. Submits that report would clearly indicate that there are regular vacancies in the establishment of the respondent board, and therefore there are no reason why respondent cannot be appointed the petitioners on regular basis. That may also be taken note in solution. And the learned counsel for the petitioner has also placed reliance the case of Devaditi Das versus Director General, All India Radio and others, reported in 2008 to GLT 6265. Ms. Aunt Devi Larner, CGSC, appearing on behalf of the respondents, on the other hand, submits that the engagement of the petitioners are made purely on honorarium basis. That is, may also take note, Lordship, honorarium basis. And initially, they were engaged in Harangajao Drainage Development Scheme, and later on the Amjud Drainage Development Scheme. The Harang Drainage Development Scheme was completed in March 2011 and handed over to the state government, whereas the works of Amjud Development Scheme was stopped after completion of embankment portion of work in 2013. After July 2013, the petitioners could not be engaged under Brahmaputra Valley Division inasmuch as the board has no estimate for payment of honorarium on engagement. Learned CGSC also submit that the claim of the respondent board that he has provided land for the Amjur scheme with the understanding that he would be provided a job is not correct, inasmuch as it was district authority, Kachar, who had acquired the land for the scheme on payment of due compensation. Therefore, the question of giving a job to the petitioner does not arise under any circumstances. It is also submitted that as per the policy of the central government with regard to appointment on compassionate ground, on maximum of 5% total vacancies is provided by calculating on the basis of direct recruitment vacancy for group C and D posts, including technical posts, and that has arisen in the year. The said policy is strictly followed by chronologically preparing the list of candidates for compassionate appointment on compassionate ground. She submits that the name of the petition numbers 1, 2, and 3 appeared at serial number 3, 37, and 43 respectively of the prepared list for compassionate appointment. However, as the Government of India policy further provides that the name of any aspirants for compassionate ground cannot be kept in the list for a period of exceeding 3 years. And therefore, the claim of the petitioners for compassionate appointment cannot be entertained as 3 years has already lapsed. She further submits that the case of the petitioner court do not come with the purview for consideration under the said compassionate appointment policy. In the facts and circumstances, the case she praised dismissed the petition. I have considered submission forwarded by the learned counsel for the parties. The affidavit of opposition filed by the respondent would clearly indicate that the petitioners are all engaged on honorary basis initially against the Harangao development scheme. That may take into note, Lordship, the contradictory statement of their affidavit also. Scheme and thereafter to the Amjur Drainage Development Scheme. The first scheme was completed in March 2011 and the latest scheme was completed in 2013. No affidavit reply has been filed by the petitioner rebuting the claim of the respondent. Therefore, in the facts and circumstances of the case, it is construed that the petitioners engaged on honorary basis to a particular scheme and their engagement ends with the completion of such scheme. The letter dated 31/12/2013 written by the respondent of court and as a to the read petitions would also indicate that the petitioner could not be engaged from August 2013 due to non-availability of approval from the competent authority. The contention of the learned counsel for the petitioners that there are regular vacancies under the respondent board as per the report dated 4/7/2013 has also been considered. However, a perusal of the reports does not indicate the existence of regular vacancies being available with the respondents board. In that view of the matter, this court is unable to give a direction to the respondents for further engagement of the petitioners on honorary basis or otherwise. It is also an admitted position that the petitioners are not engaged beyond July 2013. Therefore, no direction can also be issued for release of their wages from August 2013 onwards. Reliance placed by the learned counsel for the petitioners in the case of Vedavati Das Supra has also been considered by this court. The facts and circumstances of that case is different from the case in hand, and therefore the same does not help the petitioner. With regard to the claim for appointment compassionate ground, the affidavit of opposition filed by the respondent clearly indicate that the name of the petitioners number 1, 2, and 3 had appeared at serial number 3, 37, and 43. However, as 3 years have elapsed, the claim of the petitioner cannot be entertained in terms of the policy of the government of India with regard to appointment of compassionate ground. Therefore, this court is also unable to pass in direction to the respondents for consideration of the case for appointment of compassionate ground. Lordship may kindly to their affidavit. Their affidavit is page, yes, page 23.
Page
23. Start from page 22, Lordship, affidavit filed.
page
Annexer 8 in the review petition, I have annexed.
Yeah.
Yes, Lordship, in the paragraph of next page, paragraph number 4, regarding engagement, the petitioner showed petition number 1, Lordship got it.
Yes.
The first date of engagement, so and so date, last day of engagement, remarks column, engaged on honorary basis in watch and ward duty as night chowkidar. Lordship, there appeared against the scheme? No. Their own affidavit against the post. Silchar. Number 2 also engaged lordship on a basis in watch and ward duty of transit camp Silchar during their time. Paragraph number 3, petition number 3, engaged on a basis in watch and ward duty at Sunai subdivision, office Silchar during night time. Number 4, engaged on a basis in watch and ward duty. So here it appears that all have been engaged against the post. But next stand, paragraph 24, difference stand taken, and on that basis, lordships given direction, my learned friend submitted only placed that sub paragraph, but that was not admitted. And apart from that, I have also annexed the review petition regarding the engagement of the petitioners against the post. I am referring page number, lordship will find page 36 of the review petition. Against the report of vacancies, that documents were available, but at that time, the document we do not have. Page 36, lordships.
This is a part of the affidavit in opposition. Isn't it?
This was not a part of the, it was discovered subsequently. It was subsequently. And here also shows they have been engaged against the post, not have been engaged against the scheme. So there is an error upon the face of record. Another aspect, lordships considered, unfortunately, that appeared no vacancy. Page 21, your lordships may kindly be looked into. There is a vacancies, and at the while issuing notice, lordships will take into consideration. That's why you should notice initially also in this case. Page 21, may I read regarding vacancies, lordships, of the review petition, page 21. In the reports, that report regarding no further estimate has been granted, that's why they have not been appointed. Contractual employees have not appointed. Lordships, in the report after 5th, or may I small report, may I read, lordship? The estimate amounting to so and so only has been framed to show the probable expenditure to be incurred temporary engagement of contractual labor against vacant post of Chowkidar, lordship, vacant post under the Borakbil division, Brahmaputra board, Silchar, for the period with effect from August 2013. From August, we have not been engaged. August to March 2014, that is 8 months. Details of engagement along with reference of instruction of engagement of these persons on compensation grounds are shown in Annexure 1 and 2. Just we referred the page 36 on the review, that is the annexure. Of persons who had been engaged in different works under the Borakbeli division since 2006 as per instruction of the higher authorities of the Brahmaputra board on compassionate ground, and one person engaged to help in tracing, drawing works, etc. with effect from 1/7/2006 against vacant post of tracer by the then executive engineer, Borakbeli division, Silchar, in tracing work, and intimated to the CE INW by his letter number 21/7/2006, copy enclosure annexure 3. Moreover, there is no regular tracer in the division office. One PwC SA was engaged for tracing drawings since long back, but he will be superintended in the month of October 2013. Hence, engagement of tracer is also required in the division. In this connection, it may be mentioned here that there are no Chowkidar in both the subdivisional office at Sunai and Manipur subdivision. There is no regular Chowkidar in the division office, Silchar also. In absence of regular Chowkidar, the contractual laborers are engaged for watch and ward duty of the office at night. We have been engaged against this post, and they stayed against the scheme. That is totally incorrect. So here is the petitioner's lobby, and in respect of petitioners number 1, 2, and 3, their fathers were appointed in the Brahmaputra division, regularly appointed. Unfortunately, they expired, and we applied for. They engaged us, and suddenly from 2013 August, we are not engaged, not provided any work. And lordships, they filed an affidavit in the review petition. In the review petition, lordships, on 18/4/2018, response number 127 filed affidavit in opposition.
Yes.
Yes,
Where's the article?
here is the affidavit in paragraph number 6. They here also stated we have been engaged against the post, not against the scheme also. Subsequently, page next paragraph, like that earlier affidavit lordships, like copy paste like.
But you were not engaged on casual basis. You were engaged on basis of honorarium.
Not honorarium, at a fixed pay, lordship in the, there also their affidavit, we have been engaged fixed pay. Honorarium means particular day, if we have provided the work, we'll get the salary. But here in the case, monthly wages pay, not honorarium. In their affidavit also annex the documents also against fixed salary.
Let us see.
Yes. Fixed salary lordships, page 10 of their affidavit. Prior to that lordship, page 9. Number 1, absolution petitioner. 1937. Then another petitioner name appear next page, number 2. Subhash Rajbangshi. Number 2 serial 2063. And next, your lordship will find
Contingency.
contingency. Ram Mohan Ravidas. Okay, serial number page 11, bottom 4. And in my review also, lordships, that I have annexed.
Read it. On top,
The-
sanction is accorded for engagement of following persons on honorarium basis.
Honorarium means, lordships, I have stated in my review petition on referring the in referring the judgment of Supreme Court. Honorarium means stated in my reply, means honorarium. Your lordship will find of my reply, paragraph number 3. I will refer the judgment also. lordship. My reply, paragraph number 3, after 1, 2, 3, 4, 7, 8. After 8 line, paragraph number 3 of my reply, honorarium means a fee. Lordship, got it? Means a fee for professional service rendered, and the salary is fixed payment made periodically to a person on compensation for regular work, remuneration for service. So it means that against particular work and fixed salary. Honorarium normally means lordship without any salary or something maybe, but here is the fixed pay have been given. And regarding 3%, 5% compensation appointment, that submission is also wrong because that has been withdrawn prior to that in the affidavit that they clarified also. Regarding 3%, 5% vacancies on compensation appointment, that has also been withdrawn. They have stated in that affidavit also, lordships, and that
Page.
page, yes, lordships. Page 6 of their internal page 6, paragraph 12 of their affidavit of the department.
Yes.
That with regard to the statements made in paragraph 9, the deponent begs to state that at present there is no vacant post in Brahmaputra board to engage on compensation ground. The petition number 1 and 2 have already applied for engagement on compensation ground as per the central government rule. Up to maximum of 5% of total vacancies calculated on the basis of direct recruitment vacancies for group C and D posts, including technical posts, and has arisen in the year. This rule is strictly followed while chronologically preparing the list of candidates for compensation appointment. Since the names of the petition number 1 to 3 were included in the list, they may once again apply for appointment on compensation ground. The instructions contained in OM dated 5/5/2003 regarding time limit for compensation appointment stand withdrawn in view of Honorable Court of Allahabad judgment dated 7/5/2010. And the case of compensation appointment are to be regulated in terms of instruction issued by number OM dated 9/10/1998 as amended from time OM dated 26/7/2012. order number so and so section say, further the petitioner for is not eligible aspirant for compensation appointment and his name is not enlisted for aspirant of compensation appointment. Even on that count, 1, 2, 3 may be considered. There is a post.
Who is this OM?
OM, they have annexed lordships.
This is not OM.
Page 113 of the internal page, let's say, affidavit
This is
reply.
not in OM.
It is there,
This is an extract from the.
extract from
this
the
handbook.
Sami's handbook. That
Where is
is
this
the
OM?
my learned man can say in this, he has annexed and time limit stated in paragraph page 22, bottom lordship will find. From that portion, it has been stated in the
Page,
affidavit. Page 15, internal page of the affidavit in opposition.
yes.
Bottom column clause 3. let's say. The time limit making compensation appointment, the provisions, instructions contained in OM dated 5/5/2003 regarding time limit for compensation appointment stand withdrawn in view of the Honorable High Court of Allahabad judgment dated 7/5/2010. In the case of compensation appointment are to be regulated in terms of instructions issued by number OM dated 9/10 to 1998.
Yes, Devi, where is this OM?
I have an acknowledged this one. Poem is not.
You're basing your foundation on this OM, isn't it? Of 9/10/1998. I think which was amended on 26/7/2012.
Yes, Lordship.
Where is this OM?
Poem is.
Now, on one side, you say that the time limit has been withdrawn in terms of the judgment passed by the Allahabad High Court. Okay. And therefore, you say that now, yes, the petitioners 1, 2, and 3, they are appointed on compassionate ground, they may appoint, they may apply. However, this will be regulated subject to the OM of 9/10/1998. Good. That is the whole thing. That is the whole foundation. Where is this OM?
This OM is not with me, Lordship.
Produce that OM. On that basis, I'll dispose of this.
Yes, on the-
petition.
Next, another date may be fixed, Lordship. I'll produce this OM. Otherwise, Lordship, this review petition is not maintainable because on the this is the conditions for review is not fulfilled in this case. He is rehearing the writ petition.
No, he is not
Exactly.
rehearing this petition.
Error apparently the
There
piece of
appears to be
record.
some error because on the first hand, you said that since they were appointed on compassionate grounds and since 3 years lapsed before their case could be considered,
Lordship, originally. it is
on
not-
that ground, this court dismissed the writ petition.
On honorarium basis, they
So
were
far as the
engaged.
petitioner number 4 is concerned, there is something. The plot that he has given for, that has been,
Lordship.
They admitted also.
The
Plot.
appointment they were claiming, Lordship, as casual employees. These are the different not appointment, Lordship, engagement on honorarium basis against some scheme. After the scheme. was
anyway, you
finished,
produce that OM, we'll see after that, after you produce
And
the OM, we'll discuss.
This is different, Lordship. It is suggested that if they can be Lordship, considered under this OM. So,
What you are saying is they can apply,
Lordship.
and anyway, the application will be considered by the OM. So let's see what is the OM about.
It may be taken up on Friday or any other or Thursday, Lordship. I'll produce this OM.
Leonard Counsel for the petitioner. MSR Devi, Leonard CGC. Shall produce the OM dated 9/10/1998. And 26/7/2012. By the next date fixed. Stop. List again on. When is the next single bench fix? Huh? No, next. Ninth,
Ninth, some difficulty lordship, or eighth or 12:30. 12. Obliged.
so
Happy, dear Lordship.
is this,
Yes,
does it
exactly.
survive?
No,
Does it
it's
still
infructuous.
survive?
It's infructuous, your Lordship. The results have already been declared. And the
Then
letter,
we'll dispose of as is.
yes, your Lordship, the letter dated 9/11/2022, those, I don't think these applicants, they have passed.
Okay.
These chainmen, I don't think they have
Your
passed.
MS,
And Bordelot.
MSN Borderland, Learned Council for the Review Petitioner submits that the matter has become infructuous. Mr. M. Saranya, Learned Council appears for respondents 1 to 59.
All the private respondents.
Accordingly, this review petition is disposed of as recommends.
And if your blessing.
Three. Order.
My lord. That review matter, my lord.
Which review is this?
Last, present lordship. Lordship has directed the
My lord.
Complaint Court petitioner to take instruction regarding the so post notice.
1 minute.
Why not? For the first time.
Yes,
My lord, this, I have instruction, my lord, this so called that is yet to be, my lord, sent to me, my lord. I have not received at all. And the copy which was received from this court, my lord, from my learned friend, and I have communicated with the client, my lord. And he is out of station, my lord, Borpata district now. Now, my lord, my humble submission, will my lord edited this so called notice? Definitely, my lord, because I am the laborer. I have no power to manipulate this document. My lord, it was the document which was published under the authority of the All India Limited, my lord.
that's fine. The earlier document.
Yes.
The earlier document, but the second document which you produced in January or February,
After dismissal of this honorable.
after dismissal, that was in February, I think.
Yes.
February.
Before your retirement.
22nd of February.
That is manipulated. That
Yes,
is
yes.
what they are claiming.
Yes.
Yes. my lord.
And once they found out that that particular document was manipulated, they directed the contractor concerned who has engaged you to issue a show cause note.
Yes.
But can't you produce something that notice was served on the review petitioner?
Lordship,
My lord.
that fix, next, because we have to ask the contractor,
That's why,
because the contractor is
that
the.
you could have come prepared with that. That you have talked to the
Now-
conductor,
now-
conductor has issued a show cause notice, and this is the receipt.
Yeah, I have the impression that he has received the notice because.
No, my
so-
lord,
so
28th, my lord, I am
since he has
retired.
the-
He has retired by now, by
I am,
March.
no, no,
February.
28th,
February.
28th February, I am retired, my lord. On that particular day, they have issued the notice, which was, I am not received, my lord.
Lordship may fix the matter on next.
On the same date, I'll
Yeah.
fix it.
Yes, sir.
What date I fixed?
Well,
12. Heard Mr. D.K. Das, Learned Council for the petitioner. Mr. K. Kalida,
Yeah.
on request made by K. Kalida, Learned Standing Council. Oil India Limited, list the matter on 12 June. That day you come prepared, I'm not saying anything in the order.
Yes,
You come prepared showing that he has received the show.
Yes.
If he has not received, then we'll have to take a different turn.
Obliged, my lord.
Or
Correction of order, Lordship.
what happens?
Lordship, it should be Rinjumuni Bora instead of Rijumuni Bora. Post title, Lordship.
Where is that?
Order, Lordship. Page 9, Lordship.
Page 9. Yes,
Lordship,
post title.
Lordship, it should be Rinjumuni Bora instead of Rijumuni Bora,
RIN,
Lordship. RIN.
who typed this order?
No, Lordship is
Lordship,
typically they're on the part of the council, Lordship.
in the writ petition, my lordship, kindly see. Page 2,
Read petition.
lordship. Page 2, lordship.
Then what can we do now?
They have to file an amendment petition regarding.
This has already been disposed.
Lordship.
Then how do we change it?
Lordship, we will-
What is your difficulty actually? What is your difficulty? Is it a case that they are not honoring the judgment because your spelling is wrong or something else?
The spelling is wrong on only inadvertent mistake on the part of the council, Lordship. Kindly see the page 2 of the petition, Lordship. And I have stated in the para 4, Lordship. The name of the applicant has been incorrectly mentioned as Srimati Rijumuni Bora, who should be,
Correct, that's correct.
Lordship, which is
So
who should be Srimati Rijumuni Bora.
yes, Hendrik.
Lordship. Yeah, leave to lordship. It's
the-
only my lord that
Is a difficult position. See, writ petition is disposed, mistake is in the writ petition. How-
they have to correct it for the writ petition then. Lordship can. If my lord is allow him to correct by hand on. Already been disposed of, my lordship, my lord, that only my lord that.
Of course,
Some-
that it is a mistake because in the other pages, it's all Rinjumani. Except that in the cost title, you put Rinjumani.
Lordship, allow him.
Let him correct it.
Oh.
You correct it by hand now after the I'll pass to you. It's your mistake.
Lordship.
Right, my lord.
And put your signature also.
You have to
You are Mr. K. Barwa.
M. Alam.
Huh?
M. Alam.
M.
M. Alam. M. Alam.
Hurt Mr. M. So and so for the applicant. Stop. Also hurt Mr. K. Hendrik.
J.
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 J. Hendrik, Land Standing Council, Revenue Department. For the
Lordship, I can appear my lord that other respondents also. 1 to 6, lord.
for all the respondents. For all the respondents.
Lord.
Stop. By this application, the applicant is praying for correction of the applicant's name in the post title in the order dated 30/11/2022, by which the WBC number 4920/2018 was disposed of. Stop. Para. It is the case of the applicant that her name is Srimati Rinjumoni, Rinjumoni Bora, and not Rijumuni, as indicated in the course title of the order dated 30/11/2020. This court has perused the main writ petition, i.e. WBC 4920 of 2018. And it appears that the typographical error has crept in while typing the name of the petitioner, or typing the name of the applicant in the course title of the order dated 30/11/2022. Stop. Accordingly, this IA is allowed, and the name of the applicant oblique petitioner in WBC 4920/2018 shall read as Srimati Rinju Muni Bora and not Riju Muni Bora. I is accordingly disposed of.
Obligation.
Five.
Yes,
Ma'am.
Purgayastha, what is your problem?
My lord, at page 12, my lord. The name of the school has been written as ME school, my lord. It's a high English school.
Where?
Only M should be H
Page,
in page 12.
para?
Para, my lord, first para, there's in then third para, then fourth and fifth, my lord. Diring Patar High English School. It's not Diring Patar ME school.
Third, AK Purgayastha,
View.
D Purgayastha, legal counsel to the applicant. Also heard Mr.
T Thakuria Lordship. T Thakuria
T Thakuria,
for secondary education.
then standing counsel, secondary education.
Yes, sir.
Stop. By this application, the applicant is praying for correction of the name of the petition, appellant school,
Petitioner's school, applicant's school. my lord.
appellant school, which has been typed out as Diring Pathar MA School instead of Diring Pathar High English School in the order dated 6/9/2022, passed in WBC number 1916 of 2022. Stop. Para. Peruse the records. No, to cancel it. This court has perused the main writ petition, i.e. WBC 1916 of 2022. And it appears that a typographical error crept into it while typing the name of the applicant school oblique petitioner in the WBC 1916/2022 as Diring Pathar MA School. Stop. Which should have read as Diring Pathar High
English school.
English School. Stop. Accordingly, it is directed that wherever the name Diring Pathar MA School appears in the order dated
6/9/2022.
6/9/2022, the same shall read as Kering Khater, High English School,
High English School.
High English. Stuff. IS recording allowed.
Obliged.
Six, hearing.
Lordship wanted the cabinet memorandum of 29/3/2010. Lordship, I beg for 2 weeks time to produce the cabinet memorandum. I have
Not
produced-
2 weeks, I'm fixing all my cases here because now I'm not sitting single. And I, Indranil also must be quite busy. I'm fixing my matters on 12th of June. Can you do it by then?
Yes, Lordship, I'll give him.
Can you do it?
And on 12th, I have quite a few matters fixed. If it is not inconvenient, can it be 13th,
13th is a Tuesday, isn't it?
Tuesday? Subject to your lordship's convenience, of course.
Okay. Heard I Chowdhury, Leonard, Senior Counsel for the petition. Also heard Mr. P. Nayak, Leonard Standing Counsel, Finance.
Yes.
Finance Department, on request made by MS.
Bora, Lordship. R. Bora,
R.
the
Bora,
Agriculture
Leonard
Department.
Standing Counsel,
Agriculture Department.
Agriculture Department. List this matter again on 13th of June.
Okay.
Try to get it, but
Lordship.